Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. Today is Thursday, October 28th. It's 10:02 a.m. We're here for docket numbers 2021 143E and 2021 144E. Before we get started, let's take a brief moment of silence. Thank you, ladies and gentlemen. Present here in the hearing room, we have Commissioners C. Williams, Belzer, Powers, Caston, and Jay Williams. Joining us virtually, we have Commissioners Irvin and Thomas. Attorney Butler, if you would, please read the docket, sir.
Yes, thank you, Mr. Chairman, other members of the commission. Good morning. As the chairman has stated, before you today are docket numbers 2021 143E and 2021 144E. Duke Energy Progress LLC and Duke Energy Carolinas LLC have filed applications for approval of the Smart Saver Solar's energy efficiency program to be included as part of their suites of energy efficiency and demand-side management programs effective January 1, 2022. The commission has scheduled a hearing in these dockets beginning on October 28, 2021 at 10 a.m. Mr. Chairman and other members of the commission, the dockets are in order.
Okay, I understand we have oral arguments on preliminary motions. Is that correct? Okay. Before we address the preliminary motions, let's make sure we know who's here, because I know some folks are present, but I think some may also be virtual. Let's start with the applicant.
Good morning, Mr. Chairman, Commissioners. I'm Sam Wellborn for Duke Energy Carolinas and Duke Energy Progress. With me this morning is Ashley Cooper, outside counsel, and it's a treat to be here in real life this morning. We appreciate your accommodation.
Thank you. All right, South Carolina Coastal Conservation League.
Good morning, Mr. Chairman. This is Kate Mixon on behalf of the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Vote Solar, and the Upstate Forever and the North Carolina Sustainable Energy Association, or Clean Energy Interveners. And with me here today is Attorney Emma Clancy.
All right, so you're representing Southern Alliance for Clean Energy, Upstate Forever, North Carolina Sustainable Energy Association, and Vote Solar. Is that correct?
Yes, sir.
All right, thank you very much.
Thank you.
Solar Energy Industries Association.
Good morning, Mr. Chairman. Jeff Kirkendall here for Solar Energy Industries Association. Also have Charlie Turini here with us as well.
All right, thank you for joining us. Office of Regulatory Staff.
Good morning, Mr. Chairman. Representing ORS is myself, Andrew Bateman. I also have Ben Muschin and Alex Knowles with me. And I'll echo what Mr. Wilburn said. We really appreciate the ability to appear in person and all the accommodations that the commission has made to make that happen. Thank you all.
All right, no problem. Happy to have you all here. I will say this is probably the first true hybrid format that we've had, so just bear with us. There may be some technical difficulties as we go along the way, but we're going to do our best to work through them. All right, so preliminary motions.
Thank you, Mr. Chairman. Andrew Bateman for ORS. And we recognize the fact that there were a number of preliminary motions filed in these dockets. And ORS is flexible as to how the commission would prefer that we handle those. We could go through them sequentially. I alternatively would be happy to summarize the motions that ORS filed and then field questions as they may arise. Mr. Chairman, what I was hoping to avoid is that these oral arguments take up the better part of the day, knowing that our resources are limited, and I don't want to take away any time from the witnesses in the event the commission were to deny the motion for summary judgment. So, Mr. Chairman, how would you prefer that we proceed?
Well, thank you for sharing your thoughts regarding the time. Do you all have a estimated amount of time it will take to get through these motions to make a full and complete argument?
Mr. Chairman, on behalf of ORS, I have no estimated amount of time, but I am cognizant of the fact that there are situations where questions can make arguments go relatively lengthy. I think back to an oral argument, I think it was last week, that ended up taking about 2 hours. And if each of these motions were to take, a comparable amount of time, that would eat up the better part of the day. But no, to answer your question, I have no estimated timeline.
Yes, sir. Attorney Cooper.
Mr. Chairman, this is Ashley Cooper on behalf of the Duke companies. Mr. Chairman, I can at least say that I think we've talked, and our prepared statements are limited. So we can tell you those things we can control, which are our plans to talk to you, are somewhat limited. I think Mr. Bateman's just saying we don't know how to anticipate how many questions the commissioners may have for us.
Right. So that was my question. You sort of helped Mr. Bateman out. I'm sure you practice your oral argument. So how long is your presentation?
Yes, sir. Mine will not take long, just by itself.
Okay. So I'm thinking like 5 minutes, 10 minutes.
Yes, sir.
For each.
Mr. Chairman, I was thinking 5 minutes to respond to their motion for summary judgment, and then 5 minutes to give you an overview of our request for the affirmation of the standards.
Okay. Well, I'm going to tell you now. Well, I won't say that. I'll save that. Okay. Let's start with the motion for summary judgment.
Absolutely. Mr. Chairman, members of the commission, again, I appreciate you giving us the ability to be here in person, present these motions, and have these oral arguments in person. We filed our motion for summary judgment because despite what the applicants say, these Smart Saver programs that they've proposed fall squarely within the Solar Choice programs, which were approved pursuant to docket numbers 2020-264E and 2020-265E. Now, those programs, the Solar Choice docket programs and those dockets I just referenced, are clearly governed by 584020. Now, 584020 clearly prohibits the recovery of lost revenues. Because that is the case, and because the programs proposed by the applicants fall squarely within that, as discussed in their application, as discussed in the testimonies of multiple witnesses, there really is no doubt that these two are intrinsically linked. Because that's the case, Mr. Chairman, members of the commission, while the company may propose these programs under 583720, the DSME statutes, they may not recover lost revenues. And for that reason, based on the way the companies have structured these programs, we believe ORS is entitled to summary judgment and that these programs should be dismissed with prejudice.
All right. Any questions for Mr. Bateman, or do we want to hear from Mr. Cooper first? Any questions from the commission? All right, Attorney Cooper.
Thank you, Mr. Chairman and members of the commission. I'll be brief, and I just want to, I know we're all aware of the standard for summary judgment, but I just want to repeat just a critical part of it. Rule 56 of the South Carolina Rules of Civil Procedure allow for summary judgment only when there's no genuine issue as to any material fact, and the moving party is entitled to a judgment as a matter of law. Two parts to this. So we clearly have several differences on material aspects of fact, and we have differences on material aspects of law. For example, Mr. Bateman said that it's undeniable that these programs are solar choice programs. That's the very start where we start to diverge. We filed these programs pursuant to 583720, which is the EE DSM statute, not the solar choice statute. The solar choice statute, our solar choice program was a separate docket. It was a separate litigated proceeding. Our testimony, our witnesses are all going through the tenets of South Carolina EE law. The intervening parties filed testimony and expert testimony about these programs as EE programs. There are also disagreements in the testimony filed by ORS and the companies that discuss these tenets of EE law. For example, there are disagreements about the inputs to the tests, to the various EE tests. Mr. Witness Horry has one view about the company's inputs. Witness Huber for the companies has a different view. Witness Morgan claims that these programs, these EE programs, will cost customers money. Witness Duff for the Duke companies presents analysis proving that the savings from the program far outweigh the costs. Witness Horry attempts to characterize the programs as simply a shareholder incentive. Again, Witness Duff provides testimony and analysis that shows that customers retain 90% of the benefits from these programs. These are just a few issues of material fact that we do not agree on. There are also issues of law that we do not agree on. South Carolina law, Act 62, makes clear that clean energy programs should work in concert with energy efficiency programs. Your order in the generic docket, the Commission's holding, makes clear that solar energy can be an EE program. Yet ORS wishes to have a change in that law and say, no, you should prohibit solar from being an EE program. I also want to make, and I think this may be the most crystal point, I want to talk about this issue of the prohibition on recovery of lost revenue. And I want to really think about what this would mean if we ruled at summary judgment on this. You heard Mr. Bateman on behalf of ORS say that under the solar choice rules in South Carolina, there's a prohibition on recovering lost revenues. Now, the companies and the interveners disagree with this analysis. We believe that's looking at one line within the solar choice regulations, and it doesn't fully consider the lines above it. That the companies believe that if you take this law in the full context, you would see that under prior law, Act 236, the companies were allowed for net energy metering, rooftop solar, to recover lost revenues, and that Act 62 solely sought to distinguish solar choice under Act 62 from net energy metering under Act 236. So when you read the lines together in the full context, it's clear that this prohibition on recovery of lost revenue applies only to solar choice. It does not apply to energy efficiency programs. And think of this, in the solar choice proceeding, we had a similar dispute and a similar disagreement on applicable law. And during that proceeding, ORS and its witness, Ori, focused on one line of solar choice, and that line was to eliminate cost shift to the greatest extent practicable. Just like today, the company said, wait a minute, you have to look at the totality. You have to look at all the requirements. You have to look at the legislative intent. This is but one part. So the companies had a disagreement on the law. And it wasn't until, Mr. Chairman, on cross-examination that you asked the ORS witness Ori, their expert, said, if you looked at other parts of the law, would your recommendations change? And his answer was, yes, Mr. Chairman, it would. But it took having a full hearing. It took having the opportunity for you to ask questions. It took the opportunity to build a record. It took an opportunity for cross-examination by counsel for some of those things to come out and come forward. So respectfully, Mr. Chairman, I appreciate Mr. Bateman on behalf of ORS. They've done a great job. They're a zealous advocate. But I say there are material distinctions of fact, disagreements of fact, and there are material disagreements of the application of law, just as there were in solar choice, that makes it that the Commission should not, with all due respect, grant summary judgment. We should have a full hearing with a full record. Thank you, Mr. Chairman.
Attorney Bateman, response?
Yes, sir. I'm absolutely happy to respond. There were a number of things that Mr. Cooper brought up. The first and the last point he brought up were issues of material fact. I certainly do not.
Excuse me, Mr. Chairman. I'm sorry to interrupt Mr. Bateman. I had trouble turning on my video. But if I may just quickly provide the Clean Energy Intervener's response to ORS to add on to a few points. I'm happy to to follow as well.
Absolutely. I didn't mean to. I didn't mean to leave you out, but I would like to hear from Attorney Bateman. Then I'll allow for you to present your argument. Is that okay?
Then that sounds perfect, and I apologize for the interruption.
No problem. Thank you.
Thank you, Mr. Chairman. So, Mr. Cooper, at the beginning and end, discussed the standard for summary judgment, any issues of material fact, and I certainly don't disagree with the recitation of the standard as made by Mr. Cooper. What I do disagree with, though, is despite the fact that there are disputes as to facts in this case. That's absolutely true. One of those being the cost test. TRC, UCT, and in the event this motion for summary judgment is denied, you'll hear more about that later today. But those disputes are not germane as to whether or not the summary judgment is appropriate. The summary judgment is appropriate despite those disputes. If the commission or if any court were to take any dispute as to fact to hold that a motion for summary judgment can never be granted, it could always be overcome by some nonsensical fact attested to by the other party. Let's say ORS said today the sky is blue, and the other party said no, today the sky is green. Well, all of a sudden, does that make the motion for summary judgment inapplicable because there's now an issue of dispute as to some material fact? No, I don't think so. There are facts in dispute, absolutely, but none of those facts are germane as to whether or not the summary judgment ought to be granted. So I don't dispute, Mr. Cooper, that there are facts in dispute as this case, but I think you only get to those disputes if you deny the motion for summary judgment, and the motion for summary judgment is appropriate despite those disputes. Let's see. Mr. Cooper also discussed sort of looking to the statute. What I would point out is that this statute was passed well after the DSM-EE statutes. The General Assembly is attributed with the knowledge that they are aware of the statutes that currently exist. If they had wanted to exempt DSM-EE programs from this statute, they would have said so, but they did not say so. In fact, they said lost revenue is prohibited. And Mr. Cooper's correct that sentence preceding discusses an order related to NEM. But that does not absolve this commission or any party from looking to the plain language of the statute. The plain language says lost revenue is prohibited. That's what it says. There's no way around it. Now, the companies are seeking to recover lost revenue under programs that only exist because of this statute. As a result, they cannot now run from the governance of this statute. And the governance says no lost revenues may be recovered. Thank you, Mr. Chairman.
Ms. Clancy.
Thank you, Mr. Chairman, and thank you for the opportunity to respond. The clean energy interveners, and again, that includes the parties of South Carolina Coastal Conservation League, the Southern Alliance for Clean Energy, Upstate Forever, North Carolina Sustainable Energy Association, and Vote Solar, did just want to briefly respond to ORS's motion for summary judgment as well and echo some of the points made by the companies. Like the companies, we believe that ORS's motion is not just unsupported in law or fact, but contrary to the EFA's express intent to encourage innovation and clean energy solutions to the benefit of all ratepayers. Mr. Cooper and Mr. Bateman have discussed a bit of the disputes of fact. I'd like to focus my argument a bit on the ways in which ORS is not entitled to judgment as a matter of law, and in fact, their motion is based on a misreading of applicable law. To begin, ORS's argument depends on reading this singular sentence in section 584020I in isolation without considering the context provided by the two preceding sentences. Now, ORS has insisted that this is just merely a plain language, the plain language of the statute. They're only reading the plain language. But South Carolina law has made clear that interpreting the plain language of a statute does not and should not mean ignoring context and clearly applicable law. Indeed, in the South Carolina Supreme Court case Fox v. Moultrie, the court stated, to determine the plain meaning of a statute, courts must look at the particular statutory language at issue and the language and design of the statute as a whole. Here in section 584020I, when read as a whole, it's clear that this section is not a blanket prohibition on all lost revenue recovery, but instead accomplishes two clear objectives. First, to ensure that utilities continue to recover program costs, including those specifically defined lost revenues under the predecessor net metering program approved in order number 2015-194, specifically referenced in the statute, until full cost recovery is realized. And second, to prohibit utilities from recovering those lost revenues for Solar Choice customers that apply to interconnect on or after June 1st. Thus, it's clear that the prohibition in section 584020 is limited to the specific form of lost revenue recovery authorized under Act 236. And presumably, if this prohibition was intended to have broader application, the General Assembly would not have grouped these directives into a single subsection. I'd also like to point out and echo the company's points that by limiting its focus to this one singular sentence in a subsection in the net metering statute, ORS has ignored the applicable sections of the South Carolina Code under which the proposed program is clearly lawful and consistent with South Carolina law. The companies do not seek to recover lost revenues as limited by Act 62. They instead seek to recover net lost revenues as authorized under South Carolina Code Section 583720, a statutory provision that the South Carolina legislature, despite amending numerous other positions in Title 58, left untouched when enacting Act 62. This section explicitly allows utilities to offer incentives and to collect net lost revenues from renewable energy technologies that reduce the energy requirements of the utility. And I'd also just like to add that there are clear factual differences between the lost revenues as referenced in the context of Act 236 and the net lost revenues that are at issue in this proceeding. For one, the net lost revenues that are permitted to be recovered under Section 583720 will not correspond to bill savings tied to exported solar generation, as was the case under Act 236. In addition, the net loss revenues must recovered under Section 583720 must be verified pursuant to well-established EM&V process and will be tied only to behind the meter energy reductions that are distinct from and additional to any energy reductions that would have happened under the Solar Choice tariff alone. And finally, I'd like to just note that ORS's interpretation would lead to an absurd result that would undermine recently enacted law, specifically the EFA, where under ORS's reading, utilities would be permitted to offer EEDSM programs, all of which allow for the recovery of net lost revenues under the approved EEDSM mechanism to all customers except for customer generators enrolled in the Solar Choice program. Purely from a logistical standpoint, this result cannot be correct. It also goes against the foundational principle of statutory interpretation that courts will reject the meaning when to project a reading of a statute that would result, that would cause an absurd result. In addition, preventing customer generator participation in EE programs undermines the EFA's very pronouncement that every customer of an electrical utility has the right to a rate schedule that offers the customer a reasonable opportunity to employ such energy and cost-saving measures as energy efficiency, demand response, or on-site distributed energy resources in order to reduce consumption of electricity from the electrical utilities grid and to reduce electrical utility costs. Excuse me. And I think, and clearly customer generators are customers, but ORS's interpretation could potentially abridge their right to pursue these EE programs. More fundamentally, though, this portion of the EFA makes clear that the legislature did not intend to expand the net metering program at the expense of an EE program. And with Act 62, the General Assembly declared it to be in the public interest to allow for the development of customer-sited energy solutions like rooftop solar, energy efficiency, and demand response. There is no reason to think that the legislature intended these various components to exist in isolation from each other. And there is no basis for the law for discouraging the combination of these facets into innovative new program offerings, such as the Smart Saver Solar program. So in sum, given ORS's failure to demonstrate its entitled summary judgment as a matter of fact and law, and in light of the broader framework set forth by the EFA, the clean energy interveners would respectfully request that the Commission reject ORS's motion for summary judgment. Thank you, and thank you for the opportunity to provide a response.
Yes, ma'am.
Mr. Chairman.
Yes, sir. Commissioner Irvin.
Mr. Chairman, I appreciate the fact that all the parties have pre-filed numerous motions, and they've had an opportunity to state their positions in their filings prior to the hearing. But we've been going for more than 30 minutes now, and we haven't even got through the first motion. My suggestion, Mr. Chairman, is that the commission take these motions under advisement, because we only have 2 days scheduled for this docket. And all parties are ready to proceed with their standby witnesses, and we really need to make a record, complete record for this docket, and then we can address all pending motions in a final written order once we've had a chance to read all the parties' post hearing briefs and their proposed orders. But just in the interest of time, I think it would be best if the chair would just take the matter, all these matters under advisement, and let's go ahead and make a record and then deal with everything in the final order. Thank you, sir.
Thank you, Commissioner Irvin. Does the Solar Energy Industries Association, do you all have any comments?
No, Mr. Chairman, we joined with the other clean energy interveners response to the motion for summary judgment, and we would stand on that well-reasoned response.
All right. Attorney Bateman, do you have any response to Ms. Clancy?
Yes, sir. Just 2 points relatively quickly. There was quite a bit to unpack, but I'll make 2 quick points. Ms. Clancy discussed the goals of the EFA. There are absolutely goals stated in the EFA. One of those goals is to limit subsidization. That's exactly what this sentence essentially does. It prohibits it prohibits recovery of lost revenue. Now, these lost revenues are going to be borne by all of the company's residential customers, solar and non-solar alike. As a result, in fulfilling a portion of the goals stated in the EFA, the General Assembly intentionally put this sentence in there to limit that cross-subsidization. Another point I'd like to address is that this would lead to an absurd result. Mr. Chairman, members of the Commission, ORS is only asserting that programs which are rooted foundationally in 584020, such as these programs, only those programs are prohibited from creating lost recovery that is then recovered by the utility. This is not an edict on every DSM EE program that a net metering customer may coincidentally participate in. This is only applicable to these particular programs that the company has proposed in this situation, because these particular programs are rooted in 584020. They, according to the company's application, fall within 584020 or the solar choice programs, which are created pursuant to 584020 and are inextricably linked to 584020. You cannot have these programs without that which was passed under 584020. And for that reason, the recovery of lost revenues is prohibited. Mr. Chairman, to address I'm not sure if it was a motion or a point made by Commissioner Urban, to the extent the commission were inclined to vote on that, I would respectfully request maybe just a 5-minute recess to confer with my folks here. And to the extent the commission decided to hold over a vote on these, it obviously impacts the case. We have a number of motions to strike. Obviously, the motion for summary judgment is pretty dispositive. And additionally, I believe the company may also want to do the same. They have a motion to affirm legal standards, which would obviously also impact the remainder of the proceeding.
You want a minute to confer with your folks regarding what?
Only to the extent the commission were inclined to go ahead and vote on Commissioner Urban's, again, I'm not sure if it were a motion or a suggestion, but to the extent the commission were inclined to go ahead and vote on that to carry over its decision on these motions, we would respectfully request just a brief recess I could discuss with my client and offer any appropriate comments.
Mr. Chairman,
Yes, sir. Commissioner Urban.
my earlier comment was a suggestion to the chair, but just so that we can move along, I would formally move that all pending motions filed by the parties would be taken under advisement by the commission and disposed of in a formal final written order after reviewing all the testimony and evidence presented and giving all the parties an opportunity to submit proposed orders. So moved. In further grounds of my motion, Mr. Chair, we could spend 2 days on oral arguments for these motions. And if that's what you want to do, that's your choice. Then I would suggest that we continue the docket until a later date, because we have numerous witnesses standing ready to testify. And I just don't see how we can complete this docket in the short time that it's got 2 days on the schedule. And we have other matters pending next week. Unless the parties are prepared to work through the weekend, I don't see how we could possibly complete the docket. And that's further grounds for my motion to take all these motions under advisement. We can consider them, each and every one, in a final written order once we've had an opportunity to hear all the testimony and evidence. Thank you, Mr. Chair.
Now, Attorney Bateman, you said you wanted a moment to confer with your folks regarding the motion. So now the motion has been made. I'm just trying to understand, did you want that to happen before or after the vote? Because the motion is on the floor now.
And if I, Mr. Chairman, I'll be very brief, and Mr. Bateman, if you'll just bear with me just real quick, just in order of keeping track of where we are just to help with clarity. Mr. Chairman, I think we want to, if we could, finish the arguments we started on the motion to dismiss. I think you had looked at me to ask me if I had a response to Mr. Bateman. I think if I were able to have that opportunity just to have a response, I think that would clean up and end the arguments on the motion to dismiss. And then perhaps it would make sense to address the motion before you about the remaining motions, just for your consideration, Mr. Chairman.
Mm-hmm. Mr. Chairman, I would like to the extent it's appropriate, interject there. I believe the company gets the opportunity to respond and ORS gets the opportunity to reply, which we have now done, Mr. Chairman. I'm not sure what appropriate to go back and forth with response after response after response unless the commission saw fit.
Mm-hmm. I got you. So about conferring with your folks, you want, I want to clearly understand that request.
Yes, sir. Yes, sir. As the commission, the chairman and the commission is aware, these, at least some of these are relatively dispositive motions. And so to the extent the commission were to vote to carry them over, I would respectfully request just a really brief moment, 1 or 2 minutes, to get with my folks and offer any comments to that motion.
So the motion has been made.
Yes, sir. I would respectfully request to get with those folks before the motion is voted upon.
Right, I got you. Well, look, I know that traditionally ORS goes last, but due to the serious nature of your motion, asking that the case is dismissed with prejudice, I want to allow the company an opportunity to respond. And if you have any further response, you're welcome to make that response, and then we'll take a brief recess so you can talk with your client.
Thank you.
Yes, sir.
Thank you very much, Mr. Chairman, members of the commission, and to show my appreciation, I'll try to be very succinct and brief here. I just want to add some further context because Mr. Bateman made the point that we could assert a fact that there's a dispute that the sky is blue or something to that effect. I'm not trying to misquote, but just the best of my recollection. So just real quickly as to that, I want to read from you. What we're talking about in the section that ORS has raised is this section within section 584020 relating to solar choice. And it says electrical utilities are prohibited from recovering lost revenues associated with customer generators who apply for customer generator programs. Keyword, customer generator programs. A customer generator program, well, customer generator programs are defined in Act 62, and it specifically defines what is a customer generator. And it says it's something that generates or discharges electricity from the renewable energy resource, is interconnected, and operates in parallel phase. Clearly what this is talking about, at least in part, is the ability to generate and sell or transport energy to the utility, to export power. That's why in the definition of customer generator, it's talking about interconnection, operation in parallel. That is not what we're talking about here. While this program may be available to someone who's on solar choice, not everybody on solar choice may choose to participate. What we're talking about is not about the export of power. We're not talking about interconnection. We're not talking about operation in parallel. What we are talking about is the fact that this commission adopted procedures that encourage electric utilities and public utilities to invest in cost-effective, energy-efficient technology and energy conservation. That's right out of section 583720. And further, it talks about, if adopted, these procedures must provide incentives and cost recovery for energy suppliers and distributors who invest in energy supply and in-use technologies that are cost-effective, environmentally acceptable. So what we're talking about are material facts. We're talking about the cost effectiveness of this program and how it reduces consumption from the grid. So these are material facts that go to the heart of this. Finally, Mr. Chairman and members of the commission, Mr. Bateman said approval of this commission could lead to an absurd result. And with all due respect, I want to point out that the reason why the companies are here is because the companies are prepared to make a showing to you that there are real cost savings to all customers. And here's the important thing. If we're wrong, let's say you adopt this program in 2022. If we're wrong, you will see that in a filing in March of 2023, and this program will cease and we won't be allowed all recovery. But if we take this approach, we'll never know, we'll never see, we won't have a chance to see this ability to put together clean energy with energy efficiency and to know whether all customers can achieve a savings. Thank you very much, Mr. Chairman and members of the commission.
All right. You had anything?
Really brief, Mr. Chairman. One thing struck me at the end of Mr. Cooper's response. He said, if we take this approach, we'll never know. Mr. Chairman, ORS is not willing to gamble with consumers' monies. The statute is clear on its face. The company cannot recover lost revenues from the consumers, from the residential customers, when the program is rooted in 584020, as it so clearly is here. With that, Mr. Chairman, I respectfully request that you grant the motion for summary judgment. Thank you.
We're in recess until 10:55. Good morning, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in docket numbers 2021-143E and 2021-144E. Let's take roll. President hearing room, we have Commissioners C. Williams, Belzer, Powers, Caston, J. Williams, and joining us virtually, we have Commissioners Irvin and Thomas. Before we took a brief recess, there was a motion made by Commissioner Irvin.
Chairman Williams,
Commissioner Williams, you have the floor, ma'am.
thank you very much. While I appreciate the sentiments behind Commissioner Irvin's motion, I would like to move to table that motion.
There's been a motion made to table Commissioner Irvin's motion. Is there a second?
Second.
All right, we will vote on the motion to table, starting with District 1, Commissioner Williams,
Aye.
Vice Chair Belzer,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
No.
Commissioner Thomas,
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion is tabled. All right.
Mr. Chairman, after hearing Commissioner Irvin's concerns, we do have one way that may help expedite this process. There are a number of motions to strike, and I believe ORS and the company can certainly speak for itself, but I believe that the company agrees as well that as the testimony arises, we may be able to take up those motions to strike contemporaneously with that testimony. By doing so, we can deal with these two dispositive motions on the front end, and the remainder of the motions can be dealt with temporally as they arise, if that pleases the commission.
Okay, thank you for offering that. We appreciate it. Anything else on the motion for summary judgment?
Not from the companies, Mr. Chairman.
Okay. All right, that motion is denied. What's the next motion?
Mr. Chairman, the companies made a motion to affirm statutes, and because of the back and forth in this and the discussion about solar choice, we just wanted it to be clear in the hopes of saving time during this hearing to avoid confusion during the hearing. We wanted to affirm that that this is an energy efficiency program, that that this litigation be considered under the energy efficiency statute and it be applied in that way. So if I may begin, I just have brief remarks, and I understand the commission's eager to get started with this. I had longer proposed remarks, but I will try to streamline them, and if you will, just give me a few minutes to run through it quickly. We made this motion because we felt like the competing arguments and we knew that things were confused with the references to solar choice. What is it that we filed? We filed a program that consists of a package of requirements and features that work together to cost effectively reduce customers' grid energy usage by encouraging behind the meter generation. This was a program that was developed with feedback from a broad stakeholder engagement process. That's what helped design this program. This program was then shared and discussed in the EE Collaborative. So this is a program that has had input from folks, from individuals on all sides of the issue who've come together and helped develop this program. It's been clearly vetted and discussed in the EE Collaborative. And what does it show? The company's filings in this docket show that the programs not only promote energy efficiency, but also achieve the comprehensive set of laws and regulations applicable to EE DSM programs. For example, the companies provided data-driven analysis proving that the programs well exceeds the applicable threshold on the utility cost test, which is the critical test for evaluating these programs. I also want to point out that while I said earlier that not all solar choice customers may elect to participate in this, it's true that not all solar choice customers may even be eligible to participate in this. So it is truly a different program. It's also a program that focuses on self-consumption and not exports, a point that I made earlier. And no, we are not talking about, I want to be very clear, the companies are not seeking to recover any net loss revenues as it relates to the solar choice program. Any net loss revenues the company seeks to recover will only be in the context of the energy efficiency rules and regulations in this commission's precedent, and will relate to the savings associated with these programs. So we believe the program is consistent with this commission's recent order, which concluded that behind-the-meter consumption of solar energy is equivalent to EE. It's a finding, your finding, we believe, was consistent with Act 62 and the broad requirements of Act 62. And we believe that your finding allows a unique and added benefits arising from the combination of clean energy and energy efficiency programs coming together. Despite all this, and not to rehash it, the ORS advanced two lines of arguments. One avenue addressed these programs directly on the grounds of energy efficiency. The other, which we just discussed, addressed these programs from the context of solar choice. And so we wanted to be clear, we felt the need to file this motion to be clear to state that we must, this must be evaluated. These programs were filed as an EE programs. They should be evaluated in the context of EE statute, the Commission's EE precedent. We want to affirm that the agreement that was reached and filed and approved by this Commission, that the UCT is the primary standard. And we would ask that any testimony that is in contradiction with this or not consistent with this or the legal standards be stricken. Thank you very much, Mr. Chairman and members of the Commission.
Office of Regulatory Staff.
Thank you, Mr. Chairman. Mr. Chairman, again, similar to what Mr. Cooper said earlier, not to rehash the oral arguments that we just went through, but the company's own application and own testimony tie these programs to the solar choice dockets, to statute 5840-20. They cannot run from that because that is a fact. Despite the fact, and it's also true, that they filed these programs as a DSMEE program, they are still intrinsically tied to the solar choice dockets and that other statute. You cannot divorce the one from the other. You cannot say 583720 applies, and because of that, 584020 does not. That's not how the General Assembly intended it. That's not how the laws work. That's not how the facts of this situation, that's not what the facts of this situation dictate. The facts of this situation dictate that these programs are governed by both aspects of the DSMEE statute, 583720, and 584020. For that reason, the motion to affirm legal standards ought to be denied. Furthermore, Mr. Chairman, the motion to affirm legal standards is really just a preemptive motion to limit testimony given to this commission. It will have the impact of decreasing the flow of information from witnesses to this commission. Frankly, I think probably the decreasing transparency to this commission. And so that's another solid ground, Mr. Chairman, on which I believe this motion ought to be denied.
I was ready to rule, but I'm sure you want to respond to that. If not, I can rule now.
Mr. Chairman, thank you. I respect the fact that you're ready to move
No,
forward.
I don't want to limit you, but you know,
I appreciate
picking up the tone and tenor of the argument. So go right
I
ahead.
appreciate. Mr. Chairman, I think that we've put our points clearly before you. I think you understand our position as to why we believe this is an EE program. It should be evaluated according to the traditional EE standards and in the controlling EE legislation, statutes, and the Commission's precedent. Thank you very much for this opportunity to be heard, Mr. Chairman.
Absolutely. Motion denied. Next motion.
Mr. Chairman, you would like to go through the motions to strike?
I accept your offer to handle them at the time.
Okay.
But I want to give you the opportunity to be heard. But if you're fine with that, we can get started.
Mr. Chairman, I think understanding administrative efficiency, we do understand Commissioner Urban's point. So ORS is comfortable waiting to raise those objections temporally until the point at which the parties attempt to present that testimony into evidence.
All right. So that takes care of the third and fourth motions.
Yes, sir.
Right. All right. Applicant, are you ready to proceed? Do you all need some time before we get started, or are you ready to roll?
No, sir, we're ready to go, Mr. Chairman.
All right. Let's go.
The company would first call witnesses Linda Powers and Timothy Duff to the stand.
Okay.
Ms. Sweet. Do you know whether this is available or not, or do I need to stay down there? Do you know? I can be here. Good, great.
And let me say this while you all are preparing for the next witness. Parties and counsel that are appearing virtually, please do not allow me to forget you. I have to be honest with you, is I'm acknowledging the folks that I see in front of me, but I also remember that there are two parties and counsel that are appearing virtually. So please do not hesitate to interject if you feel like I've skipped over you.
Thank you, Mr. Chairman. This is Kate Mixon. We will be sure to do so and appreciate you recognizing those of us that are just here on the screen.
Yes, ma'am. My computer charger, I think it's in my car. I'll get it at the next break. Sir, we're ready whenever you are.
Thank you, Mr. Chairman. Ms. Sweet, have they been sworn in yet? Okay, thank you.
Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you, Ms. Sweet. We will start with Ms. Powers. Good morning, Ms. Powers. Will you please state your name for the record?
My name is Linda Powers.
And does your new last name represent a change from your pre-filed testimony?
Yes, it does.
By whom are you employed and in what capacity?
I'm employed by Duke Energy Corporation as a Senior Strategy and Collaboration Manager for the Carolinas.
Did you prepare or cause to be prepared 8 pages of pre-filed direct testimony in this proceeding?
Yes.
If I asked you the same questions that were contained within your pre-filed direct testimony this morning, would your answers be the same?
Yes, they would.
with the exception of your last name, is that right?
Yes, that would be different.
And do you have any other changes apart from your name change to your pre-filed direct testimony this morning?
No, I don't.
Mr. Chairman, I would ask that Ms. Powers' pre-filed direct testimony be entered into the record as if given orally from the stand.
Ms. Powers, pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Ms. Powers, would you please provide a summary of your pre-filed direct testimony to the commission at this time?
Yes, I will.
Mr. Chairman, could I
Vice
ask,
Chair Belzer.
could I ask Ms. Powers to pull that a little closer? I'm having trouble hearing her here. I'm not sure about people out virtually.
All right, is that better? Thanks. Good morning. Good morning, Chairman and Commissioners. The purpose of my testimony is to explain how the proposed program will operate within the company's suites of EEDSM programs. The companies are proposing a one-time incentive of 36 cents a watt based on the direct current nameplate rating of a customer's solar photovoltaic or PV system. The incentive may be assigned to a solar installer or leasing company if the customer is in a lease agreement. And the incentive will lead to the installation of solar PV systems by customers who might choose not to install rooftop solar due to the underlying economics. The program is only available to customers with all-electric service who become new Solar Choice metering customers on or after January 1st, 2022, and comply with the interconnection and installation requirements of the Residential Solar Choice Rider. Eligible customers must also participate in the winter Bring Your Own Thermostat demand response program for a period of 25 years. This 25-year term is appropriate based on industry standards related to the useful life of a solar PV system. Customers may unenroll from the winter BYOT program, but they will be required to pay $200 for each year of the 25-year contract period that the customer is not enrolled, up to the amount of their initial incentive payment. Additionally, if the customer opts out of more demand response events than allowed, the customer will be charged a $200 fee, representing an annual prorated share of the incentive. Although there is no limit to the number of customers who can participate in the program, DEC projects that approximately 3,112 customers will participate cumulatively over 5 years, and DEP projects 595 customers will participate. If the program is approved, the companies will recover costs as they do for any other EEDSM program, which is through the company's annual EEDSM rider proceedings pursuant to the applicable cost recovery mechanism. Further, the companies will evaluate the projected savings of the program through evaluation, measurement, and verification, or EM&V, like we do the other EEDSM programs. This concludes the summary of my testimony.
Thank you, Ms. Powers. Mr. Duff, would you please state your name for the record?
Timothy Duff,
And by whom are you employed and in what capacity?
Duke Energy Business Services, General Manager, Grid Strategy Enablement.
And how long have you worked in the energy industry?
Approximately 20 years.
How long have you worked with energy efficiency and demand-side management programs?
Approximately 11 years.
And what is your educational background?
I have 2 bachelor degrees, one in General Business Administration and one in Political Economics, and then I have a Master's of Business Administration as well.
Thank you. Have you ever been involved with any organizations related to your profession?
Yes, I served on the board of directors of the Midwest Energy Efficiency Alliance, as well as the Southeast Energy Efficiency Alliance.
In your current role, could you please describe for the commission your current responsibilities at the company?
I'm responsible for the development and implementation of the regulatory recovery mechanisms and business models associated with energy efficiency. I regularly represent the company at industry forums and present at conferences related to energy efficiency, and often have provided expert witness testimony in support of regulatory filings related to energy efficiency programs. In 2021, I gained additional responsibilities related to technologies that impact the grid, such as battery storage, electric transportation, and distributed energy resources.
Thank you, Mr. Duff. Mr. Chairman, based upon Mr. Duff's experience in matters related to energy efficiency and demand-side management programs and related areas, I propose to tender this witness as an expert in the field of energy efficiency and demand-side management programs and measures.
Any cross-examination from ORS?
Not with respect to Mr. Duff's qualifications as an expert, Mr. Chairman.
All right. Mr. Duff is qualified at your request, all those areas.
Thank you, Mr. Chairman. Mr. Duff, did you prepare or cause to be prepared 10 pages of pre-filed direct testimony that were filed in this proceeding?
I did.
If I asked you the same questions that were contained within your pre-filed direct testimony this morning, would your answers be the same?
Yes, there was amended direct pre-filed testimony filed.
Excuse me, thank you. So if I were to ask you the same questions that were contained within your amended or revised pre-filed direct testimony this morning, would your answers be the same?
Yes, they would.
Thank you. Mr. Chairman, I would ask that Mr. Duff's pre-filed amended direct testimony be entered into the record as if given orally from the stand.
Mr. Duff's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Duff, did you also prepare or cause to be prepared 2 exhibits that were attached to your pre-filed direct testimony?
Yes, I did.
Do you have any changes to those exhibits at this time?
Not to my knowledge.
Mr. Chairman, I would ask that Mr. Duff's 2 pre-filed direct exhibits be entered into the record as I believe the first hearing exhibit.
Mr. Duff's 2 pre-filed exhibits will be marked as a composite exhibit and entered into the record as hearing exhibit 1.
Thank you, sir. Mr. Duff, would you please provide a summary of your direct testimony at this time?
Certainly. Good morning, Commissioners. Thank you for the opportunity to present to you today. The purpose of my testimony is to give an overview of the program, explain why it is appropriately considered EE and DSM program, and explain how it will operate within the company's suite of EE and DSM programs. EE programs are designed to incentivize customers to reduce their energy consumption, and the program is designed to incentivize adoption of solar photovoltaic or PV systems to help customers reducing their energy consumption from the grid. This is similar to other at-home EE equipment like high-efficiency heat pumps, heavier attic insulation, and it produces utility system benefits for all customers. The proposed program aligns with characteristics of the company's other EE programs and measures by reducing demand on the grid. Further, the programs align with South Carolina Code Section 583720, which defines EE and DSM programs to include those implemented for the reduction of energy requirements of utility or its customers. The program further aligns with the provision of South Carolina Code Section 583720 that requires incentives and cost recovery be provided for energy suppliers and distributors who invest in energy supply and end-use technologies that are cost-effective, environmentally acceptable, and reduce energy consumption or demand. Currently, effective EE-DSM mechanisms approved by the Commission also support approval of the program. The mechanisms require that the proposed EE-DSM programs be 1. Commercially available and sufficiently mature, 2. Applicable to the utility service area, demographics, and climate, and 3. Feasible for a utility DSM and EE program, which would include cost effectiveness. The proposed program meets those requirements. Per the Commission's approved EE-DSM mechanisms, EE-DSM programs must be evaluated under the Utility Cost Test, or UCT, and receive a score of at least 1.0. The program's cost-effectiveness score under the UCT was 2.52 for DEC and 1.95 for DEP. This means that it would actually be uneconomic and cost customers more money for the companies not to pursue implementation of the program. All customers will benefit from participants' reduced demand, which will reduce utility system costs through avoided electric production, avoided electric capacity, and avoided electric transmission and distribution investments. This ultimately results in savings to all customers. The estimated total avoided costs of the programs are approximately $26.5 million for DEC and $3.9 million for DEP, compared to the approximate cost of the program, which are approximately $10.5 million for DEC and $2.0 million for DEP. a net savings for both DEC and DEP customers overall. Low-income customers will benefit from the overall system savings, and the companies also plan to engage with the EE-DSM Collaborative to expand the program for low to moderate income customers. In conclusion, I recommend the Commission approve the program as it is consistent with the EE-DSM statute and the Commission-approved mechanism, and because all customers will enjoy the benefits of lower ongoing system costs as a direct result of the program. This concludes my testimony summary.
Thank you, Mr. Duff. And Ms. Powers, if you'll please answer questions of council or the commission.
All right. So let me ask this: is there counsel for the self-described clean energy interveners that will offer cross-examination, or should I call on each party?
Oh, Mr. Chairman, we don't have any questions for Mr. Duff and Ms. Powers at this time.
Okay. And does that include Solar Energy Industries Association?
We also do not have any questions for these witnesses at this time.
Okay. Office of Regulatory Staff?
Thank you, Mr. Chairman. Good morning, Mr. Duff, Ms. Powers. How are y'all doing this morning?
Well, thank you.
Okay. Ms. Powers, I don't have any questions for you this morning. Mr. Duff, you filed the applications in these dockets as an exhibit to your direct testimony, correct?
Yes.
I'd like to start just talking about the structure of the proposed programs a little bit. Am I correct that the foundation of the proposed programs is the Solar Choice permanent tariff that the commission recently approved?
The modeling of the program is based off of the reduction in self-consumption by the customer who would install the solar array.
So let me ask, every single customer who would participate in the program would participate also on the permanent Solar Choice tariff recently approved by the commission, right?
I believe in order to look at the total generation from the solar PV, that would be correct. But the EE program does not look at the generation output. It looks at the load reduction associated with the consumer behind the meter.
Appreciate the clarification. So the answer to the prior question in the shortest form is yes.
Can you ask it again? I just want to make sure I understand it.
That's all right. Thank you, Mr. Duff. The proposed program takes the Solar Choice tariff and overlays an incentive on top of the tariff rates. Is that correct?
The energy efficiency incentive is calculated based off of a 36 cents per watt incentive amount based off of the nameplate of the solar voltaic. It's the energy savings which have been modeled are based off of the reduction in self-consumption. I think that's what you're asking for.
So the 36 cent per watt incentive is given to customers who sign up for the program. Let's just start there. Is that correct?
Yes, subject to the review of the installation as well as their signing up for the winter BYOT program.
Okay, and also signing up for the Solar Choice permanent tariff, correct?
I believe they would sign up for that tariff, yes.
Okay, and the incentive as described in the proposed tariff for the programs is called the rooftop incentive, right?
It's the Smart Saver Solar program.
Let's see. So in the Smart Saver Solar program, Mr. Duff, I'm looking at it's I believe Exhibit 1 to your direct testimony. And within Exhibit 1, it's Exhibit A. So it's the Smart Saver Solar Energy Efficiency Program. And the incentive is called the Rooftop Incentive. Is that correct?
That's what it's in quotes, yes, on the tariff, I believe.
Thank you. And so it sounds like, based on the quotation there, the purpose of the incentive is to get customers to install solar on their house, right?
The purpose of the program is to get a reduction in consumption associated with the customer installing solar PV on the roof, yes.
Okay, the reduction in consumption through the solar PV.
The reduction in consumption that's achieved because of it, yes.
And I guess I should clarify, it's the reduction in consumption from the utilities grid.
Correct. It's the behind the meter reduction in consumption.
So it's not related to the customer's overall level of electricity consumption for all purposes.
Their overall level of energy consumption will be impacted, and it's that reduction in overall energy consumption that's factored into the valuation of the program.
Okay, and Mr. Duff, exhibit number 2 to your direct testimony is the application. And I guess that would be your direct testimony filed in each docket. One would be DEC's application, the other DEP's.
That's correct.
Okay. On page 2 of the application, paragraph 5.
Excuse me, I just want to, does it matter which company's okay, I just want to make sure we're on the same page.
Page 2, paragraph 5. Oh, excuse me, it must be page 3, I'm sorry.
Okay.
The very end of the last sentence of the paragraph, the program would defray the upfront costs of solar PV by providing an incentive reflective of the system benefits that such installations provide. Did I read that correctly?
That's what it says, yes.
So, is it your position that these system benefits are not reflected in the rates of the permanent solar choice tariff?
I haven't made that position. The position that I've taken is that the incentive that is being proposed as part of this proposed program is designed to cost effectively incentivize customers to reduce consumption through the installation of rooftop solar.
Now, with respect to the permanent solar choice tariff for behind the meter consumption, there's a 1-to-1 rate. Is that correct?
I I really don't know. I'm not an expert on the solar choice tariff. I can answer around EE programs specifically.
I see. Have you read the solar choice tariff?
I may have looked at it once, not recently.
Okay. And so, but I think we did discuss earlier that every single customer who participates in the program is also going to have to sign up for the solar choice permanent tariff. Isn't that correct?
I believe if they're net metering, they would have to sign up. But if, to the extent that that's a requirement of the tariff to be, of the solar choice to be a net metering customer, then I would say yes.
Are you aware of any exceptions to that requirement?
Again, I'm not an expert, but I'm not aware of any.
And you are responsible for the implementation of the proposed program, correct, Mr. Duff?
I have responsibility associated with the implementation through our program management team meets the terms of what was proposed and filed, as well as communicating with stakeholders, the ongoing process of implementation, and my team oversees the independent third-party evaluation of EM&V that is done for all EE and DSM programs.
Thank you. Let me ask, Mr. Duff, do you know, well, have you read the commission's order in the Duke Solar Choice dockets?
I believe I've read it over, yes.
Okay. And the commission's order did expressly address the system benefits provided by rooftop PV, isn't that correct?
I would have to read it again, but I believe it does reference it.
Okay. Let me pull up ORS Cross Exhibit 15. I'm going to go ahead and email that to the parties. Okay, I've sent that. Mr. Chairman, permission to approach the witness.
Yes.
Thank you.
Okay, so Mr. Duff, what I've handed you is some excerpts from Commission Order Number 2021-390, which the Commission entered in docket numbers 2020-264E and 265E. And if you just flip it open, the very first page will be page 25 of the order. And if you look at the second paragraph, and then look at the third sentence.
Does it begin with the word "the"?
Yeah. And tell me if I'm.
At the end of the line?
Thank you. Yeah.
Okay.
That was a good way to put it. The Commission finds, for purposes of this proceeding, that this export credit reflects an appropriate approximation of the benefit provided to the system. Did I read that correctly?
You read what it said, yes.
Okay, Mr. Duff, turning back to your application, page 4. the first paragraph, which is a continuation of paragraph 6 from the preceding page. The first full sentence. Pursuant to the agreement referenced above and to reflect the value of the anticipated savings, the company proposes an upfront rooftop solar incentive of 36 cents per watt DC. Did I read that correctly?
Yes, that's what it says.
And the value of the incentive, that 36 cents per watt DC, that number was a negotiated number agreed to by the companies and the solar and clean energy interveners to the Duke Solar Choice docket, correct?
I believe it was the result of discussions with parties, correct?
Okay. It was the result of discussions. Okay, thank you. So the incentive isn't specifically based on a quantitative analysis of system benefits, correct?
No, I disagree with that characterization. The incentive was looked at based off of the system avoided costs, consistent with how the approved cost recovery mechanism says that it would be reviewed, to get a range of potential incentives. And then through discussions with parties, the exact amount of the incentive necessary to deliver those avoided cost benefits through the system savings was developed.
Has Duke put forward any quantitative analysis in these dockets showing how it calculated the 36 cent per watt DC incentive?
Not to my knowledge.
So the system benefits that you have testified that the incentive helps deliver, these are the same kind of benefits that were considered by the commission in the Solar Choice docket, right?
I read it differently. Again, it's tough because it's out of context and I haven't read the whole document, but this seems like it's talking about exports versus a reduction in consumption. So I don't, based off of my layman's read of this, I don't think they're the same thing, no.
And so let me ask this. Under the Solar Choice order, the value of exports is avoided cost?
It doesn't say it in that sentence. I would have to read the order to be able to say that. But if you're saying it says it subject to check, I would.
Okay, I do appreciate that. And the value of the behind the meter consumption determined in the Solar Choice order for the permanent Solar Choice tariff, that's the 1-to-1 rate, right?
Again, I don't know. I wasn't part of developing that.
Okay.
I can really only speak with respect to the cost effectiveness and valuation of the system benefits that were calculated consistent with the commission approved mechanism for cost recovery.
Okay. Mr. Duff, let me ask this one. The 1-to-1 rate, that's a higher amount than the avoided cost rate, right?
Again, I don't know. I'm sorry.
Okay, no worries. All right, let me try just one more on that line real quick. The commission's determination of those benefits in the solar the system benefits in the Solar Choice docket, that is reflected in the Solar Choice tariff, right?
Again, subject to check. I did not read the entire order. I did read the excerpt you said, and it talks about the export credit. Again, if I read it, I may agree with you, but it's hard without having the full time to read it.
No, yeah. Thank you, Mr. Duff. Thank you. I do appreciate that. All right, so the average total incentive that Duke expects to pay under the program It's between $3,500 and $3,600 on average. Is that right?
I believe that's correct.
The funds for that incentive will be collected from all of Duke's residential customers. Is that correct?
It would be a program cost that would be collected through the EE and DSM riders from residential customers, correct?
Okay. Mr. Duff, would you agree that the typical rooftop solar customer is going to be a higher income customer than the median residential customer?
Objection, Mr. Chairman. The question calls for speculation.
Mr. Chairman, if he knows, he can answer.
I think it's a fair question. Objection denied.
I don't know.
Okay. Let's see. Do you know how much the average rooftop solar installation costs? Ballpark?
I think it's in the 18,000 range, somewhere in there. Again, it depends on leasing, so it's kind of tough, but I believe the price tag is around in that 15 to 18,000 range, depending on the array and the features of the arrays.
Okay. And there can even with financing be a cash outlay up front of several $1,000s, right?
Again, I'm not in the solar installation business, but if you know that, then I'll accept that.
Okay. So let's see. I asked you about the income of the typical rooftop solar customer. Let me ask you, do you know if the household wealth of the typical solar customer is going to be higher than that of the typical residential customer?
I don't know.
Mr. Duff, if a customer enrolled in the proposed program and received the rooftop solar incentive, Duke would be entitled to earn net lost revenues and a performance incentive based on that customer's generation. Is that correct?
No, that's not correct.
Okay. Which can you specify, is there a particular part in there that was incorrect?
I can tell you how the lost revenues and shareholder incentive, if that would help. Yeah, sure.
Let's do that.
Yeah, sure. So the net present value of the avoided costs is compared to the net present value of the program costs associated with the customer participating, and then those net benefits are, which is the difference between the avoided costs and the program costs, those are multiplied by 10.6%, which determines the utility incentive. It's an effective way to promote the utility to minimize the cost of energy efficiency while maximizing the impact and avoided cost savings that the system realizes. It's based off of the UCT net benefit calculation.
Okay.
And the lost revenues will be based off of the actual reduction in consumption that the customer delivers.
Which is that reduction in consumption is what the customer consumes from their customer cited generation.
It would be the reduction in consumption associated with their adoption of the rooftop solar. But again, it's the behind the meter piece.
Behind the meter. Okay, but now if a customer becomes a customer generator under just the Solar Choice tariff, they're not enrolled in the proposed program, in that case, Duke is not going to earn net lost revenue on the customer's self-consumption or its export.
Duke Energy, Carolinas or Progress, will only recognize and request recovery of program costs, net lost revenues, and shareholder incentive associated with customers that participate in the program.
Let me ask that again, Mr. Duff. I'm not sure if that answered my question. if a customer enrolls in the Solar Choice Tariff Program but doesn't enroll in the proposed program, that customer's generation is not going to create net lost revenue that Duke would be eligible to collect. Is that correct?
I believe so. Let me say it again. Net lost revenues are only calculated and requested for recovery associated with the actual impacts from program participants. So if I believe you said the Solar Choice customer is not participating in the program, then clearly the program is not driving a reduction in self-consumption and hence would not qualify for net lost revenue recovery.
Okay. So, okay. Net lost revenue and PPI that the company earns from customers who enroll in the proposed program, that's essentially profit. Is that correct?
I don't think I would categorize it as profit. I think I would categorize it as the net loss revenue recovery is the permitted recovery of cost to the company that would be a disincentive to it aggressively pursuing customer adoption of energy efficiency programs. And the performance incentive is designed to promote the company doing as much of it as it can in a cost-effective manner. Is it in addition to costs? Yes. But it is not like a return on cost. It is a sharing of the net system benefits that are being realized by customers.
Okay. And the Duke will be able to capture those net loss revenues and that PPI if a customer participates in solar as EE, but not if the customer participates in the Solar Choice Tariff standing alone.
The net loss recovery associated with the reduction in consumption is only permitted associated with program participants.
Okay, thank you. Mr. Duff, let me talk to you quickly about the cost-benefit calculations. Page 6 of the application, paragraph 10, summarizes Duke's cost-effectiveness test results for the proposed programs. Is that correct?
That's correct.
Let's see. And in Duke's calculations of the benefits of solar PV, the companies used a calculation of 25 years, correct?
That's correct.
Do you agree that if fewer years were used, that the total benefits would be lower?
If it recognized fewer years, the avoided costs would be lower, which would lower the UCT. But the measure life was recognized consistent with the manufacturer's guidelines, which is how it is done for energy efficiency.
Okay. Okay. So let me ask, do you agree that solar PV fits the general definition of being a distributed energy resource?
I think it can.
And are you familiar with the Commission's order number 2021-569 entered in the generic net metering docket?
I know it's out there, but I can't say it's something I'm super familiar with.
Okay. I'm going to send out ORS Cross Exhibit 14. Okay, and ORS Cross Exhibit 14 is excerpts from order number 2021-569. And looking at ordering paragraph 4, beginning on page 51. Do you see where I am, Mr. Duff?
Yes, I do. It's at the bottom of the page.
Okay. Let me know if I'm reading correctly from the commission's order in the generic docket. In this and future proceedings, for the purposes of cost-benefit analysis and avoided capacity calculation for DER, solar PV shall be considered with a 20-year lifespan. Did I read that correctly?
That's what it says, yes.
Okay. And just to make sure that I understand this correctly, Duke calculated the benefits in this case with a 25-year lifespan.
Yes, as I said, for two reasons. A, that was the manufacturer's guidance on the life of the program, so that's why it's recognized. And then B, the participation requirement for BYOT is also 25 years. So to not have those same periods would have been problematic in the cost effectiveness analysis.
Great. Thank you very much for your time here this morning, Mr. Duff.
All right. Commissioner questions?
And Mr. Chairman, I would just please ask if the commission would take judicial notice of its final order in docket numbers 2020-264 and 265E, as well as its final order in the generic net metering docket from earlier this year.
Yes, sir. Notice taken.
Thank you.
Mr. Chairman.
Commissioner I'm sorry, Commissioner Urban, I hear you, but Commissioner Caston was a little bit quicker than you were. So Commissioner Caston,
No problem. I'll stand by. Thank you.
Commissioner Urban, Commissioner Caston just deferred to you. Commissioner Urban.
Thank you, Commissioner Caston. Mr. Duff, I have a couple of follow-up questions for you. First of all, it's my understanding that Office of Regulatory Staff has stipulated to your qualifications as an expert in energy efficiency. So if you were looking at program as a disinterested party, how would you characterize this program given your experience and expertise in this field for over 20 years?
I would view it as a utility incentive designed to cost effectively promote a customer adopting an energy efficient technology, which means that it's going to be a piece of equipment or investment that will reduce their energy consumption and burden on the grid.
And so is there any doubt in your mind as to whether or not this is an energy efficiency program?
No, that's why we filed it this way.
And does it meet the cost efficiency test?
Yes, as was brought up, the UCT is over 1.0 for both DEP and DEC. And consistent with the commission-approved mechanism that was settled with all parties, including the ORS, the UCT was determined to be the determinative test. Not that other tests couldn't be looked at, but the determinative test to determine whether a program was cost-effective and should be offered was deemed to be the UCT in that mechanism that was approved by the commission last year.
Now, you were asked on cross-examination about, quote, talking with other parties. Was that in the context of a stakeholder process where you invited everyone to come in and participate?
So the the negotiation regarding the incentive amount was done, as I said, after we did some modeling to determine a range of incentives that could be cost effective. But then there was stakeholder engagement around that amount that was agreed upon that would still be within the cost effectiveness range, and when accompanied with the requirement to participate in the winter-focused BYOT program, would make the overall program cost-effective and attractive for customers. That was one stakeholder set of discussions. However, after that, after the 36 cents was agreed upon, the companies then took the proposed program both before final modeling as well as after final modeling. So it took it to its energy efficiency and DSM collaborative multiple times and received support and no objection from any of the members of the EE and DS collaborative that questioned that this was an energy efficiency program in South Carolina.
Was the Office of Regulatory Staff invited to be a part of this process?
Yes, they were, and as Ms. Powers could tell you, as she keeps track of the minutes and the participants, they were in attendance in those meetings.
Thank you. And let's talk a bit about the purpose of the program. As I understand it, one of the purposes is to reduce demand. Is that correct?
That is correct.
And in that context, this would help reduce the winter peak and I suppose the summer peak if the program is implemented. Would that be true?
That is correct. It has both seasonal impacts, but particularly with the requirement for the winter-focused BYOT program, it is targeting that winter capacity, which is so important with respect to utility planning.
And so, given the fact that it will reduce the winter peak, and we all know how important that is and what a worthy goal that is, would that benefit the non-participating residential customers in the territorial jurisdiction?
Yes, as I mentioned, when you look at the avoided capacity value as part of the overall cost effectiveness analysis under the utility cost test, the overall avoided cost benefits, so avoided energy, avoided capacity, and avoided transmission and distribution investment, is far greater than the program cost that would be recovered from customers. So yes, the utility system benefits are greater, which would translate into customers' future rates.
In fact, that would reduce rates for all residential customers in the long run, correct?
It's tough to say for all, but in modeling terms, yes, it looks at it holistically.
And so, just to wrap it up, then there are benefits to non-participating customers.
That is correct.
And one of those benefits would mean that additional capacity would not have to expand as rapidly, given the energy efficiency impact. Is that true?
That's correct. It's one of the reasons that the company looks so favorably on its stakeholder engagement and the constructive regulatory mechanism it operates under in South Carolina, because it really has a constructive construct to go out and pursue energy efficiency and demand response programs like this that will get aggressive adoption and reduce those traditional supply side investments.
Thank you, sir. No further questions.
Commissioner Caston.
Thank you, Chairman Williams. I don't want Ms. Powell to feel neglected. So I was going to ask her, and then I'll ask you a question or two if it's okay. And it's Powers, correct?
It is.
Okay. Relative to those estimates, the participants in the program over 5 years, I think there's 3,112 DEC customers, 595 DEP customers. I've been just naturally curious, how did the Duke companies determine that? How did you derive that?
So we looked at the average number of applications that were coming in for solar customers from 2017 to 2020. And using that average, we got an idea of what a reasonable range was. And then took applications that came in 2020 specifically as our baseline, stripped out of those numbers customers that would not be able or willing to participate in the winter Bring Your Own Thermostat demand response program. And the number that was left was the number we could project would be a similar number that would participate from 2022 on. So, using the baselines based on the old economics of net metering, we got an idea of what the general interest was, and then could use that as our projection for interest under the new economics.
Okay, so generally, you based it off of historical information?
Yes, sir.
Did projection, okay. Good enough. Thank you. Mr. Duff, and this isn't a trick question, I promise you. I really don't have any of those. But what is your definition of energy efficiency?
Energy efficiency is a reduction in energy consumption or usage that results in a reduction of burden on the electric grid.
Okay. I mean, that's not like written in energy efficient dictionary anywhere. That's just Mr.
There are multiple definitions out there. The ORS's witness put a definition out there. There's a statutory definition in South Carolina. You ask me, and that's how I look at it.
And you answered the question, and I appreciate it, because I actually have looked at some of those definitions just through the course of time in this stuff. Similar, what would your definition of demand side management be?
So demand side management is more broad. I think that when many times demand side management is used to encompass both EE and demand response, sometimes it just refers to demand response. I'm going to define it in that context because I think we've already talked about energy efficiency. Demand response, or DSM, would be the reduction in the peak utility usage during a utility peak, but doesn't necessarily mean a total reduction, because you could be shifting it, so you're reducing the peak, which is the high cost period. And so that's what a demand response program does. It promotes the customer not using during a certain period because that's when energy is at its most expensive, or it may not even be available. And it incentivizes the customer to move the usage to a different time. It doesn't deliver avoided energy benefits in the cost effectiveness test. It only delivers avoided capacity value and avoided transmission and distribution investments that are driven by the need to support the peak.
Okay. I understand I guess the desired direction or argument. Well, I'm not saying I understand or taking any position either way, but 583720, it does talk about procedures must provide incentives and cost recovery for energy suppliers and distributors who invest in energy supply and end-use technologies that are cost-effective, environmentally acceptable, and reduce energy consumption or demand. that just kind of stood out to me when I read it, when it says reduce energy consumption or demand. Is your argument, or Duke's, that rooftop solar reduces energy consumption or demand for that customer? I understand the argument that you're saying it reduces it on the grid, I guess when the sun's shining. So is the demand reduced or is it simply shifted?
It can be both, Commissioner. The Commissioner Caston, a demand response program like Winter BYOT, it shifts. It's clearly designed to shift. We currently have no energy savings or a total reduction in consumption associated with it. A energy efficiency program like the Smart Saver Solar program that has that requirement to participate in winter focused ER, it delivers energy savings. Now, if some of those energy savings occur during the peak periods, then it will reduce demand and create capacity savings. But it depends on when those energy savings occur.
Okay. And what I'm trying to get my head around, I mean, I've heard the arguments so far and read them. And I think in terms of, say, this room, it's lighted up by the current bulbs we have. And in my house previously, I used to have the incandescent bulbs that you learn not to touch. And now I have the LED version bulbs. Matter of fact, at times I think they're brighter.
Yeah.
But the use of that bulb allows me to do the exact same thing to light my room, but using less electricity. That makes sense to me. That's an energy efficient bulb. It does the same thing, but uses less. It's like, say, 20 SEER HVAC unit, which I think was referenced. So I'm hearing the arguments, but I'm still having trouble getting my head around, okay, that reduced energy consumption and demand by virtue of having a solar panel is energy efficiency.
Sure. Can I explain how I make it work in my mind?
Yes.
So just as you went out and bought a light bulb and you chose that because of the economics to put in that energy efficient LED and you're reducing your consumption. If you chose to put on a solar panel on your roof, it's going to reduce the energy that's being consumed from the grid. It is harnessing energy that's there and using it to reduce consumption. It's a more efficient way for the customer to go out and make the investment in the PV panels to reduce consumption than not to go out and reduce consumption by making the panel.
I absolutely understand that. And I won't keep belaboring the point, need to mull this more. But on the one hand, I could put on my solar panels and theoretically, I might use more electricity than I would normally use during that day because I got it and it's costing me nothing. So when I think of energy efficiency, I think of I'm getting the same using less electricity, not I'm using the same electricity or more potentially electricity, but let's just take that and put it over here. Demand side management. What does the term management, what does that mean to you, management?
So that management, again, in the definition that I talked about earlier, is the active management of a device to shift usage away from a peak.
Okay. But again, if we're talking about energy efficiency or shifting, and I understand, I mean, because I like flatter, smaller peaks too. It's great because that'll help everything. No two ways about it. But, and this is just me, you know, management implies that someone controls the demand on the customer side of the meter. Demand side management. I mean, that's just, when I read the words, it just seems to make sense to me. So if I have rooftop panels, how is that managed?
So, as you recall, there is a requirement that the customer participate in the winter focused BYOT, which means the thermostat will be controlled by the utility around peak periods. So to the extent that the energy reduction that's occurring is associated with the output of the solar, it will be factored into that demand reduction. You're having control on when that consumption reduction is occurring.
I agree, and I understand that, and that's wonderful when you're talking about peaking. I think it makes a lot of sense. Again, and I'll not belabor the point anymore. I'm just still struggling to understand or get my head around the energy efficiency doing the same using less electricity versus, you know, not.
Commissioner, can I make one more point?
Yes.
I think it's important to focus on the word. It's energy efficiency, not electric efficiency. And so what you're talking about, and this is very pertinent when you talk about what we put into our testimony regarding the fact that the commission has approved solar water heating as a energy efficiency program. It reduces the amount of electricity that's consumed, but the energy is coming from the thermal energy of the sun to heat water. So it's the energy is being used. It's about energy efficiency, not just electric efficiency. And that's the key, I think, that you're struggling with, if I'm interpreting it correctly, is you have to think about energy, not just electricity.
I agree. Point well made, and I have no argument with that. How many states have a program like this?
I'm not aware of any, but I can really only speak on an expert level from the states that I'm used to operating in and familiar and have covered through the boards that I've been a member of. So I'm not aware of any at this time. There are a lot of solar water heating programs out there, but not this type of a program.
Okay. I noticed in witness Horry's direct testimony on page 10, he said that, and I think I'm quoting, and then I'm not, I apologize, said even California does not classify solar as EE. And he makes note that California is very, very solar oriented and and I found that interesting. What are your thoughts relative to that?
So my thoughts are, I think it's very interesting that he's picking California, which is a state where a lot of his experience is from. So clearly, if a state that he's helped influence doesn't include it, I think he wants to point to that. But I don't think simply because California, who frankly, we don't generally model our programs after California. It's a very different utility system, state, climate. There's a whole bunch of reasons why we don't model our programs off of what California does. So the fact that he's pointing at California makes perfect sense given his experience to me. But I don't think that pointing to California as somebody who hasn't done it is any valid reason on why South Carolina, in its overall context, can't be, frankly, a leader in including this as part of our energy efficiency portfolio.
So you're arguing that even though California does not recognize solar, rooftop, whatever, as energy efficiency, the state of South Carolina and this commission should recognize solar rooftop panels as energy efficiency, not alternative generation or different generation.
So I am saying that the commission, based off of my understanding of the definition of energy efficiency in South Carolina statute, I don't know California's, so I can't speak to California's, but based off of the statutory definition of energy efficiency that I know in South Carolina, as well as the economics that are in place, I believe that the reduction in consumption that a customer experiences by installing rooftop PV should be considered energy efficiency in South Carolina, yes.
Okay. And you mentioned stakeholders. I've heard that mentioned a time or two, broad range of stakeholders, which I believe that can always be a good thing, not always a pleasant thing, but always a good thing. That said, I didn't fully understand where Duke brought these stakeholders in. It seems like it was at some way down the road. And my first thought was, and I applaud all those efforts, by the way. Who or what person, entity, organization represented? I think you said ORS was in that particular stakeholder group. Other than ORS, was there anyone that represented the customer, whether that would be a participating or non-participating customer?
So there are a number of stakeholder groups that participate in our collaborative, groups like Upstate Forever, a number of groups around low income advocacy. So we feel like our energy efficiency collaborative is a very broad base of stakeholders that do represent the interests of customers on a broad base. And as I said, the ORS is and has been a longtime participant in the collaborative. And we view it as a real opportunity to make sure that what we're putting forward is being vetted with them kind of ahead of time, as well as with all the other stakeholders. So hopefully we can avoid these contentious proceedings.
May I add something to that? I lead the Carolinas Collaborative, this EEDSM Collaborative, and we have 35 members from 25 different organizations. And this might be a little off, but as an example of what came out of the collaborative as a result of talking about this program, one of the collaborative members heard about the program and was working with Habitat for Humanity on a 29-house development in Greenville, and now is including the possibility of adding solar panels under this Solar EE program to those Habitat for Humanity houses. So I just offer that as an example of how so many different groups are represented and how this has been such a topic of conversation in the collaborative meetings and among collaborative members that work is already being done and considered how we can use this and utilize this for the best interests of our customers. So low-income groups are definitely represented along with 25 other organizations.
Thank you. Final question, I think. I think, of course, this, if you can answer this, I think Attorney Cooper had mentioned that if we are wrong, it's in Duke, that Duke and the PSC would know in a year and simply not reimburse us, something to that effect. Did I understand that kind of correctly?
Certainly, I'll go over that process with you. So just as with all of our energy efficiency programs, once the program's approved, it will be offered to customers. We track the cost, the participation, and location and things of where participation's occurring, and we share those with our collaborative twice a year, after the second quarter and at the end of the year. So there'll be ongoing conversations about the performance. Then, as part of the annual rider filing, we will actually go in and show what the actual costs were, the actual energy savings to the extent we've already done EM&V. You have to have a statistically significant sample in order to make the measurement and verification accurate. But assuming that you would have the significant enough participation to have that sample, we would do the measurement and verification, and then those results of what the actual reduction in consumption, the actual shifting of demand, anything associated with the program that's leading to potential recovery of net lost revenues, the company's incentive, and program costs are all trued up as part of that actual rider filing, which goes to the commission for DEC in March and for DEP in August. So that lag would have a little bit different amounts of time. So you might be a little bit more likely to have the first M&V done for DEP in time for the filing. March might be a little tight, but even if we don't have the EM&V, we will give an update as to how the program is doing with respect to customer sign up, the energy savings associated with it, as well as any other things that would change the variables of the avoided costs, and we'll make the commission aware of that as we see cost recovery. If the commission finds that the costs are outweighing the benefits, or that there is some other inherent problem with the program, at that point, they could tell us to cancel it, and we would stop incurring any costs. The lost revenues and incentive would be trued up for what that actual amount was that was problematic.
Okay. And I told you this is my final question, but that kind of led to another one. So if this were adopted, why would non-participating customers, why would there not be a cost shift based on all of these particular incentives?
One of the cost effectiveness tests that looks at the impact on non-participants is the ratepayer impact measure test.
Mm-hmm.
And so if that test is above a 1, or how close it is to 1, tells you relatively what the long-term impact to rates would be on non-participants. And so the cost effectiveness scores under RIM for the two programs, for DEP and DEC respectively, are right below or at 1. And so we don't believe that there is a cost shift. The system benefits that are being driven by the reduction in consumption from the participating customers, as well as that shift of demand associated with the thermostat that you pointed out, those benefits will lead to a long-term reduction in rates.
I'm not ignoring you.
No problem.
I was listening, and I'm looking for something along those lines that you said. Of course, I can't find it. But that said, and I think looking back at Mr. Horry's testimony, I think it was his direct, I can't recall, but he did mention the TRC. And I was curious, did Duke look at that or consider that, or did you just use the UCT?
So Duke performed the cost effectiveness analysis for all 4 cost effectiveness screens and provided the requested information to the ORS when they asked for it. The company is not saying that the test should not be looked at, but just as previously, when under the old approved cost recovery mechanism, TRC was the predominant test. So if it didn't pass TRC and it passed all the other tests, then we wouldn't offer it. When the settling parties, including the ORS, put a settlement in front of the commission to revise that mechanism, it moved to the UCT as the predominant test. So we're not saying that we shouldn't look at those other tests. What we're saying is that those tests inform you about things like the long-term impact to rates, the customer economics, the participant test, and actually the TRC is just a conglomeration of the RIM and participant test. So we actually think looking at the RIM and participant test, it tells you where there may be a winner or a loser, because a participant test below 1 means that the economics don't quite stack up. Mm-hmm. If the RIM test is below 1, it says non-participants, there could be a slight subsidy in long-term rates. Everything else held constant. So looking at those, it actually tells you where the winners and losers are. The TRC is a conglomerate. It tells you it holistically, as Witness Ori points out, but the TRC test is not what we have focused on, because our approved mechanism that the commission approved says UCT, and just as every other program that the ORS reviewed in their reports this year for the company, they said it passes the UCT, so it's cost effective. That's all we're saying, is that it is the test that makes the decision, not that the other tests shouldn't be considered by the commission, because they do provide information. We could point to some other things about how the TRC was calculated out of conservatism because it is no longer the predominant test, but that's a discussion for another time, I think.
Okay, but you do agree that at least those 2 tests in particular, and I guess probably the others, are the result you get is only as good as the information that's used, correct?
That's correct. Which is why the company feels like we were conservative with the assumptions that we used and did it consistent with every other EE program. We didn't try and game it and say, you should treat this differently, you should treat that differently. We treated the energy and demand reductions associated with the customer participation the exact same we do for every other EE program, consistent with the approved mechanism. And so we feel like the assumptions we made were conservative. How it was done spot on with what the commission expects for a new program approval.
I really think that was my last question on this one. Thank you, Mr. Duff. No more questions, Mr. Chairman.
Mr. Chairman.
Yes, ma'am. Vice Chair Belzer, do you have questions?
Yes.
Let's take a 10-minute break and come back at 12:45. Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in docket numbers 2021-143E and 2021-144E. Present in the hearing room, we have Commissioners C. Williams, Belzer, Powers, Caston, J. Williams, and joining us virtually, we have Commissioners Urban and Thomas. Before we continue with Commissioner questions, I just want to remind council and witnesses that during breaks, while you're still on the oath, you're not to discuss your testimony with counsel. I think I heard you advise your clients or your witnesses of that, Attorney Welborn, but not only just counsel, but you shouldn't discuss your testimony with anyone. Just want to offer that to you all. Vice Chair Belzer.
Thank you, Mr. Chairman. I'm getting ready to say Ms. Schaefer, but Ms. Powers, you discussed, I believe, with Commissioner Caston, some of the participants in the stakeholder group, and you indicated there is low-income customer representation in that stakeholder group. Yet in the application states that the program is a result of collaboration with Southern Environmental Law Center on behalf of the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Upstate Forever, the North Carolina Sustainable Energy Association, Sunrun, Vote Solar, and Solar Energy Industries Association. There's no mention there of low-income representation in the development of the program. Can you explain that difference to me?
Yeah, so that would be what Witness Duff was referring to. We have multiple stakeholder groups going on, and so that was the solar stipulating parties, and they were the ones that came up with the original idea for the program. And then whenever we have energy efficiency and demand side management programs, we always vet them with the collaborative earlier rather than later. So the initial idea for the program and the nuts and bolts, the range for the incentive, some of the general ideas about how it was going to work were developed in that group. And then in November 2020, we brought the program to the Energy Efficiency and Demand Side Management Collaborative, and that's the group that I facilitate that has representation from low-income groups and environmental groups and academic groups and trade associations. All kinds of groups are represented there. And so we presented it in November 2020 to get initial feedback. We came back again in January 2021, March 2021, July 2021 with that, what we call the Carolinas Collaborative, the EEDSM group.
Okay, thank you for that clarification. And I'm not sure either one of you can take this. Can anybody give me better or more detail on how the 36-cent watt incentive was derived?
I can do that. So our folks, for modeling purposes, they estimated the savings that would be achieved by customers using their behind the meter solar PV appropriately paired with demand response, and determined a range of savings. And then working with the stipulating parties, those solar groups, settled on 36 cents. So it was a result of negotiations in that those groups helped us to determine what would be a high enough amount to make a customer make a decision, but still be within the range where we knew it would be cost effective.
And is that a one-time payment on the size of the solar array that is put on, or is that a monthly payment, or how is that done?
It's a one-time incentive that will be paid once the panels are active.
Okay. Thank you. That's all I have, Mr. Chairman.
Mr. Chairman, this is Commissioner Thomas.
Yes, sir. Commissioner Thomas, you have the floor.
Thank you. So first off, I would just like to say that I appreciate the company thinking about this in a different and innovative way. I think we would all agree that this is a new program that may not have been tried anywhere else. And whether it's approved or not, I would just like to say that I do appreciate the company thinking about things in a different way and looking at potentially doing new and different things. And appreciate you including different parties and trying to work up the program. And but having said that, I would like to ask a couple of questions. So can the company, or can you, either of you two, promise or guarantee that this program is not going to cost non-participating customers?
So what I can tell you is that based off of the modeling, which, as I said, included some conservative assumptions, and the scores that came back for the program, we don't believe that non-participants will see an increase in long-term rates because of this. Again, it's tough to make that blanket statement. When you model across a wide path of customers. So it's hard for me to say that I guarantee that no customer will see an increase. What I can tell you is that with the industry and South Carolina accepted models, the indications are that the program will not cause customers to have long-term rates increases, which would be those of non-participants.
Okay, thank you for that. So just taking that a step further, if the program does end up being approved, and if it does turn out that it does have costs that are going to non-participants, do you think it would be just and reasonable for this commission to disallow the recovery of those costs?
No, I don't. And the reason I say that is the RIM is not, which is that the ratepayer impact measure test, which is also called the non-participant test in the industry. It is not the majorative test in terms of saying we should not do a program. It gives you the indication of what it's doing. And I would say that we could work with parties to try and come up with improvements to change the program. But there are a number of programs that this commission has approved in our EE and DSM portfolio that do not pass the RIM test. And those are still offered because the UCT is looking at the investment that the utility is making on behalf of customers compared to that of a supply side investment. So I don't think that it should be canceled if the commission chose to cancel the program because of that. Far be it for me to say they can't, but I do think that it would not be consistent with how we've in South Carolina looked at energy efficiency programs, nor do I think it would be consistent with the long-term interests of the utility system, which are measured appropriately by the utility cost test as the predominant test.
Okay. So the company can put together the numbers under both methods, and those can be reviewed and audited by ORS, and the determination can be made as to what those costs are and where they potentially might fall. Do you agree with that?
Yes, we provide that analysis on an annual basis. And as I said, the ORS this year reviewed our programs and found that the programs passed the UCT and should continue to be offered. Those that were struggling to pass UCT, they had suggestions that we should improve them. So I will say that I think that there is the mechanism in place. I also want to add that there are also commission programs that don't pass any of the cost effectiveness tests generally, that are offered to low income regardless because of the desire to help low income customers become more energy efficient. And as I said in my direct testimony, if this program's approved, we plan on moving forward almost immediately with our EE Collaborative to start developing a low-income version of this program that would help customers specifically identified as low-income attain the reductions in consumption and energy savings that can be achieved through the adoption of rooftop solar and the winter BYOT thermostat program.
Okay, thank you for that. So basically, though, would you agree that this commission does have the authority to make a decision as to whether or not, if it does turn out to be costing a group of customers, we would have the authority to make a decision as to whether those costs could be recovered or not? Would you agree with that?
I believe that's within the commission's authority.
Okay. Thank you. I appreciate all of that. That's all I have.
Mr. Chairman.
Commissioner Powers.
Thank you, Mr. Chairman. And thank you all for being here today. Ms. Powers, I don't have any questions for you, but you have a great last name now. Mr. Duff, I guess I'm just trying to follow the money. As a non-solar customer, let's say that I were to go and thicken up the insulation in my ceiling, change my light bulbs, take all sort of what we normally call an energy efficiency step. And at the same time, just say, well, you know what? I'm going to put a timer on the lights. I'm going to cut my bill in half. If I do that as a non-solar customer, you get no subsidization or any sort of money out of it. The solar customer, it seems, with the, your cost being able to recover the money, it's a different treatment. I'm trying to understand how, and I think Commissioner Irvin mentioned how long-term, how this may be beneficial to all customers. If you could explain that, and is there any way to quantify long-term when the non-solar customer would recover just as the solar customer does?
So the benefit is realized is really not different. If you did those, what you called more traditional energy efficiency programs, if you did those participating through the company's programs, meaning you got an incentive to put in a more efficient air conditioner or a more efficient light bulb or smart thermostat, if you got that incentive and you were a solar or were not a solar customer, all customers will pay that cost just as they would on this program, because the amount of incentive that's being provided is less than the avoided cost benefits that the energy savings are justifying. It's not looking at the output of solar, it's looking at the energy and demand reductions that are occurring from a customer participating in this program, albeit they're receiving an incentive, but it's cost effective because the regular supply side investments that would be required absent that reduction are greater than than the cost that you're providing to the customer as an incentive and then recovering across all residential customers.
So you're saying that this does not result in any cost shift to the ratepayer?
Based off of the results of the RIM test, the ratepayer impact measure test, which is how energy efficiency programs look at the value to non-participants, it is small if non-existent for program non-participants based off of the RIM scores that we have today.
Well, the incentive under the statute is to, do away with any cost shift. You're saying it's minute. Does it increase the cost shift as it exists when you say it's minute or not measurable, or I'm trying to quantify.
So it's, again, it's a ratio versus 1.0 is how the rim looks. And I guess I can do this. I provided it in my rebuttal testimony. When you look at the program with the BYOT in it, for DEC, it has a rim of 0.99. Now, so it's just short of 1.0. For DEP, it's 1.1. And again, I will emphasize that the company was conservative in the inputs that it put in to the program because we didn't want it to be overstated. We wanted to do it in a conservative manner consistent with how these programs are measured. And based off of a 0.99 and a 1.11, I feel very confident saying that the modeling indicates that there is almost no cross subsidy to non-participant. I'm sorry, the rim. I read the wrong rim test. I read the participant test. The rim, which is 1.31 for DEC and 1.0 for DEP, that's actually, it is. So I can say unequivocally that based off of these rim scores that were modeled, the program does not have a long-term increase on customers' rates.
Okay. And you feel long-term it's going to help everyone?
Yes, that's justified by the UCT, which looks at it as the utility being investing on behalf of customers as a whole to manage the system in the low-cost manner. And that's what the utility cost test tells us, and that's what the very positive scores of the UCT are indicating, that the overall system benefits or reduction in the need for supply-side investment will far exceed the costs that are being recovered for customers over the long term. Again, it's you don't just buy a kWh at a time, you're building a system. So it is, I have to caveat it with it's over time, but these tests have been used in South Carolina as well as across the country for a long time and are, in my view, an accurate indication of the different perspectives of cost effectiveness.
Okay. All right, well, thank you very much. So we're just trying to figure all this out.
It's complicated. By no means is it easy.
Thank you. Thank you, Mr. Chairman.
Yes, sir. So, Mr. Duff, Ms. Powers, I have a few questions for you. Either of you can answer the question. I think Mr. Duff probably will be answering most, if not all, of the questions, but I'm open to hearing from both of you. So, obviously, my colleagues and I are trying to understand the arguments that are being put forth by the companies and the parties, along with the Office of Regulatory Staff. Now, I think I understand what's going on, but I'm going to ask you all to help me understand more, or correct me if my understanding is completely off. Now, the company's position is that the Smart Saver solar program is an energy efficiency program. Is that fair to say?
That is correct.
Okay. It's an energy efficiency program that incentivizes rooftop solar. Is that fair to say?
Correct.
Okay. All right. And you're bringing this program to us for consideration, and your ultimate goal is approval based on the law in Act 62. Is that fair to say as well?
We're bringing it under the South Carolina law, yes.
Right, okay. And regardless of what our feelings may be about the law is the law, and we have to follow the law. Is that also fair to say?
I would never tell a commissioner what their job is, but yes, that's my understanding.
I think that's a fair
Yes.
fair statement. The law is the law. Okay. And so I like using examples. They help me understand things better. So if you can work with me here, I think I may be able to clear things up for myself. So, have you ever heard of the concept of a loophole?
In general terms, yes.
Okay, all right. And in your general understanding of the term loophole, would it be fair to say that that is a way to get around maybe a rule, a practice, or maybe even a law? Is that a fair statement?
I think that's a fair statement.
Okay. Have you ever filed your taxes?
Every year.
Every year. Okay. Have you ever in your life heard of loopholes in the tax code?
I've heard that phrase referenced with respect to taxes, yes.
But regardless of whether or not loopholes exist or do not exist, the law is the law. The tax code is what it is. Is that fair?
That's the way I interpret it, yes.
Right. Me too. Me too. Have you ever heard of an American, maybe someone considered a wealthy business owner, taking advantage of loopholes in the tax code?
I've heard that general statement made, yes.
Right. Okay. And who knows whether they do or not, but the argument is that they do. And some may consider that unfair, regardless of whether or not it's the law. Is that fair to say?
I think people are always going to have differing opinions of what's fair or not.
That's right. I agree with you on that. But regardless of what they think is fair or unfair, that wealthy business owner, for example, hasn't broken any law by taking advantage of a loophole. Is that fair to say?
If the loophole is consistent with the law, and I'm saying loophole is the term you used it, then I don't think they've broken a law, no.
Right. Okay. So here, Duke, the Duke companies are putting forth energy efficiency program. At least they believe it's an energy efficiency program, and you believe it's an energy efficiency program. Is that correct?
Yes, I do.
All right. Using rooftop solar as the source of reducing consumption, right? Okay. And there seems to be arguments that, or not even seems to be, there are arguments from the Office of Regulatory Staff that this program is not energy efficient, not an energy efficient program, but it should be a solar choice program. Is that fair to say?
I don't believe they're saying the program is a solar choice program. I think they are saying that in their view, there are components of it that would fall under solar choice. That's my understanding of their argument. I don't want to make it for them, but that's how I understand it.
I got you. And that very well may be their argument, but they definitely don't believe it's energy efficient, an energy efficient program.
No, based off of their witness's testimony, it appears as though he contends it's generation.
Right. Okay. Now, in your understanding of the solar choice tariff, someone, a residential customer or even commercial, could deploy rooftop solar and take advantage of the solar choice tariff that we decided several months ago, correct?
I believe the tariff is out there and applicable. As I said, I'm not a super big expert on solar choice, so I don't want to make any definitive statements, but yes, if the tariff's approved out there, then yes, customers can participate.
Right, right. And we're definitely going to stay at the wave top level. Okay. We're not going to do a deep dive. So under your proposed Smart Saver Solar program, someone who already has rooftop solar deployed on their roof, or installed on their roof, they could, if we approve this program, they could take advantage of this program in January.
No.
Okay. And
it's only customers who are electing to put the rooftop solar on as a result of the ability to receive the incentive. So it's a new solar participant.
Right. And so, I think you see where I'm going. So just to be clear, anyone who already has rooftop solar deployed, before January 1, 2022, if we approve this program, this Smart Saver Solar program, will not be able to take advantage of this program.
No, they would not be able to take advantage of this program.
Okay. And let's say someone decided to install rooftop solar on their roof after January 1, 2022. They don't have to apply for this the Smart Saver Solar program, do they?
No, there's no requirement for them to participate, and not all customers would be eligible to participate.
Mm-hmm. And in fact, if they were to participate, there are more requirements for the Smart Solar, all the S's, the Smart Saver Solar program. There's more requirements for the 3S program than for just installing rooftop solar.
That is correct.
Right. You have to have a specific thermostat. Is that right?
You have to have a type of thermostat that's compatible with our demand response program, yes.
Right. And that demand response thermostat allows the company to control or manage, if you will, that customer's thermostat during certain hours. Is that fair to say?
That's correct.
Okay. That's not required if I just wanted to install rooftop solar on my roof.
That is correct, as well as that program is only eligible to customers with electric heat.
Mm-hmm.
So that's another set of customers. If you don't have electric heat, you wouldn't be eligible to participate in the program as well.
Okay. The 3S program.
That's
Right.
correct.
That's
Smart
my
Saver
words.
Solar.
My words, not yours. Is there what about insulation? Insulation. Do you have to have certain requirements for insulation in your home under the Smart Saver Solar program?
No, you do not.
Okay. What about other energy efficiency requirements? Are there any other than the thermostat?
We did not tie any other program requirements around eligibility for participating in other energy efficiency programs. But we do plan, and I say this in my direct testimony, we do plan to use this program to help inform customers of other energy efficiency opportunities, as well as to make sure that the customer is well situated for the rooftop solar adoption. Meaning, if a customer with a northeast facing roof were to come to us and say, we want to put on the rooftop solar, we would inform them that they likely would not be reducing their consumption by nearly as much because of the inefficient installation of this rooftop solar.
Understood. And so to be clear, if I'm understanding you correctly, the only energy efficiency requirement is the thermostat.
That is the only programmatic eligibility requirement, yes.
Okay, got to have the thermostat.
And give us control.
Well, right, exactly. I mean, that's the purpose of the thermostat, right?
Yeah.
Right, okay. So a customer will be able to deploy rooftop solar on their roof, take advantage of the solar choice tariff, correct?
I believe so.
Mm-hmm. And if they decide to install a thermostat that gives you control, the company's control of the thermostat, they will also be able to take advantage of the Smart Saver Solar program.
Yes, if they choose to participate and they meet those eligibility requirements, they could participate in it, yes.
Can I add to that? They would also have to use an installer from our Trade Ally network, and they would have to agree to allow our third-party vendor to EM&V them after the fact. So they have those requirements as well.
All right. So as long as they agree to the thermostat, give you control, their third-party vendors and other requirements, that customer will benefit from the solar choice tariff approved by the commission, which that order is out there and the benefits are listed, in addition to benefiting from whatever the incentives are for the Smart Saver Solar program, right?
Yes, we actually hope the availability of the incentive was what would make them want to and choose to install the solar, to your point.
All right. And the law, you believe the law allows that?
Yes, I do.
So regardless of whether or not it appears as double dipping, it doesn't matter because the law allows it, right?
I won't get into the double dipping, but yes, I believe the law allows it.
Right, right. And regardless of whether or not there's a cost shift, because it's a energy efficiency program, you don't believe that, I believe it's 58-20-40I applies in terms of the utility recovering lost revenue.
I don't believe it applies because it's not the same animal. The lost revenues, and I believe Company Witness Ford goes into greater detail on this, but net lost revenues are specific to energy efficiency and are calculated in a specific manner. I don't believe that that is the same lost revenue that is contemplated and that you were discussing in, I'm sorry, I forgot the statutory reference you've made, but that's in that statutory reference. Yeah, so 58-40-29.
I'm sorry, 58-40-20I.
59-40-20I?
Oh, am I saying it wrong?
No, I just want to make sure I said it correctly.
No, 58. So I can't say smart, saver, solar.
Yeah, and I can't say the statute, so we're both.
Oh, man, the blind are leading the blind. I'm sorry. So 58, section 58, 58-40-20, paragraph I. The last sentence, electrical utilities are prohibited from recovering lost revenues associated with customer generators who apply for customer generator programs on or after June 1st, 2021. You don't think that's applicable to the Smart Saver Solar program because it's a different animal?
It's a different animal, and there are other forms of customer generators that are included in the energy efficiency program today. I referenced them in my rebuttal testimony regarding topping cycle CHP systems. So I do think it's a different animal from what was being contemplated in the statute that you read off.
No, I get it. I mean, obviously you would have to agree that it's a different animal or you would not have offered the program.
That's correct.
Right? Okay. That's all I have for now.
Mr. Chairman.
Vice Chair Belzer, then Commissioner Cass. Well, let's do this. Commissioner Williams has not answered any questions yet. May we give her?
I just wanted a clarification on something that.
Oh, go right ahead.
I apologize, Commissioner Williams. Ms. Powers, with regard, when you were speaking about the company-approved contractors, you indicated something about a third-party vendor and then something after that, and I wrote down EMV. I don't know if that was right. I didn't understand what you had answered about the third-party vendor.
So we have a third party that conducts our evaluation, measurement, and verification, EMNV. That's what I was
EMNV,
referencing.
okay, thank you.
Commissioner Williams and Commissioner Caston.
Thank you, Chairman Williams, and thank you for being here and for your endurance and sticking with us on all these questions. I'm going to go all over the place because my notes are kind of all over the place. But let me start. I believe that, Ms. Powers, you talked about participants would, if they opted out of a certain number of demand response opportunities, then they wouldn't qualify. Could you give me a little bit more background on that?
Yeah, so that's actually one of the requirements of our demand response program is that if a customer opts out of more than 2 events, they forfeit their incentive.
So let me see if this is what you mean. If you're doing the bring your own thermostat and you don't allow a cutback in your solar or your energy use associated with the thermostat, that would be 2 events. If you chose 2
yes,
times.
if you do that twice. So we allow them to opt out. We don't want to make the the program burdensome and force people to unenroll. So we give them twice that they get to opt out of participation. And if they do that more than twice, then they forfeit their incentive. That's true for all BYOT customers. For the solar customers, they would also have to pay back a portion of their initial rooftop incentive because that was tied to their BYOT participation.
And is that twice in a month?
Twice in a year.
Okay. Anything else on that?
I don't think so, unless there's
Okay.
something else you
Just,
okay.
I kind of stopped you with more questions, so I just wanted to give you that opportunity. Is the BYOT a demand-side management program?
Yes. Yes, it is.
And what element of this proposal, and either of you can answer, is energy efficiency?
I'll let Witness Duff answer that.
So the Smart Saver Solar is an energy efficiency program because it's reducing the amount of customer consumption. As Witness Powers said, the eligibility requirement that they participate in BYOT is a demand response program. So Smart Saver Solar is the EE, but it has an eligibility requirement that you participate in DSM.
Okay.
And by putting those two things together, we get a complete package of savings and deliver maximum benefits to the system.
Okay. Witness Duff, in your summary, as well as in your testimony, you refer to 58-37-20. And in it, there's reference to energy suppliers and distributors. How would you describe, who is an energy supplier and distributor?
From my vantage point, that's Duke Energy.
So what does that mean in terms of, I'm going to read from your testimony lines 13 and 14, that requires incentives and cost recovery be provided for energy, so incentives and cost recovery be provided for energy suppliers and distributors who invest in energy supply and end-use technologies that are cost-effective, et cetera, et cetera.
Right. So the company, Duke, whether it be Progress or Carolinas, gives a financial incentive to the customer to provide the energy reduction in consumption or shifting of demand. And the company is allowed to recover those costs of incentive as well as is eligible for the performance incentive to motivate it to do it. And as I said before, our performance incentive is exceedingly effective in motivating Duke to work with stakeholders to find programs that get the most energy and capacity savings at the least cost, because then our incentive goes up, but it only goes up to the extent that the total benefit goes up.
Mm-hmm. Mm-hmm.
Spending more is not the answer.
And I think my question is, what I heard you say is that by offering incentives, the Duke companies as suppliers and distributors are investing in energy supply and end-use technologies.
We're not owning it, so we're not in. That's a little bit of the nuances. We're not owning it. It's not a rate-based asset, but we are incentivizing the purchase of those energy-consuming devices or control devices that allow us to give customers an incentive to shift their demand.
And I understand that. I'm just trying to understand. In my mind, I'm trying to get my head around and understand whether the companies meet that element of the statute. And so,
in my mind, we're supplying energy to customers and distributing it to them.
Right.
And they are giving us reductions in the demands on that
Mm-hmm.
supply and delivery.
Mm-hmm. Excuse me, bear with me.
Problem.
So I think this is also in Witness Duff's testimony. You talk about really what we were just talking about, incentivizing installation of solar facilities. Is it reasonable to assume that a customer will use less energy just because he or she relies on electricity generated from rooftop solar panels rather than from traditional sources?
We did not model any reduction in the electricity that is used. We modeled a reduction in the electricity that is used from the grid, which is how all of our energy efficiency programs look at it.
You may have just answered this question, but do you observe any different levels of use of energy for when customers are using solar?
I don't have any knowledge of any change in customer energy consumption if they have solar, other than we know that there is a reduction in consumption from the grid, which is what we're measuring and modeling from an avoided cost standpoint.
How successful was the solar hot water heater program?
It struggled to get participation because it was an expensive technology, and the incentive that we could offer at the time didn't motivate customers to participate. So it didn't end up being a cost-effective long-term program offering for us. So we're no longer offering it. But again, we have to look at the market conditions and the economics that the customers are experiencing. But it was really a result of the price for the technology compared to the savings that the reduction in consumption that was generated from that we were experiencing that would justify the program being continued.
And when was that program? I kind of recall
It was
2009.
it was actually in one of DEP's original programs.
And what year?
I believe it was brought forward in 2009 or 10.
Yeah. Okay.
I have to plead a little ignorance in that it was filed prior to the merger of Duke and Progress.
Certainly a lot's changed
Yes.
technologically since then and cost-wise.
Yeah.
Did you, in looking at the Smart Saver Solar Program, hope I got that in the right order, because I like Chairman Williams's 3S. Did you look at the income levels of people who are likely to take advantage of the program?
We didn't explicitly model customer income levels in terms of looking at the program, no. Okay. Again, we think that the comparison we did is the incentive amount compared to the kind of incremental cost. So that's how we were trying to figure out that you're giving enough incentive to actually motivate them to make the investment.
But in doing that, did you evaluate who you would motivate?
Not to my knowledge did we look at income levels.
Okay. And I believe one of you, maybe Witness Powers, talks about kind of a next step if this is approved. Mm-hmm. Is it appropriate to talk any about that? Because that did sort of relate to income levels. I don't know if it's appropriate, but I figure some attorney will stand up if it's not.
Yeah, I brought it up. It was in my direct testimony. It's something that we've agreed to develop a low-income version of the program offering. A lot of times, so we have low-income programs today, mm-hmm. and they have the same measures or energy efficiency equipment in them, but many times will have a far higher or cover the complete cost, because obviously low-income customers cannot afford it. So I think our vision is to work with stakeholders to identify how we would need to incentivize the level of that 36 cents a watt that was developed for this to make it cost effective. Again, low-income programs don't have to be cost effective, but we would want to make sure that we weren't providing too much incentive or too little incentive to motivate those customers. So I think we'll look a lot more at customer income levels when we start developing the low-income program. But it didn't make a lot of sense at this point for us to start looking at it from a low-income perspective until we understood if it could be offered to the mass market.
Okay. Yeah, that's similar to what we've done with our other Smart Saver measures. So, for instance, we incentivize high efficiency air conditioners, which are really expensive. But once we get the program going and get our trade ally network and kind of get the kinks out, then we can look at how do we get this to the customers that can't participate on their own. And then you see us start to expand into these low income programs with the same measures. We'll follow the same pattern with Smart Saver Solar.
Does the BYOT program have a lower income component?
No, it doesn't, although we do install some smart thermostats as part of our low-income programs. And so once they get the thermostat, then they can enroll in the BYOT program. So the BYOT program doesn't have a low-income component, but other programs that get that measure installed in their house do.
Okay. So in effect, you really do. It's just not under that umbrella. Did I understand you right?
We definitely make sure that low-income customers have equal access to those programs.
Smart thermostats? Right.
Yes,
Okay.
we just might have to do it through another venue.
Yeah, I think that's a great point, and I don't want to belabor it, but we look at that all the time with respect to, is there a way to use mass market programs to effectively reach low-income customers so you don't have to have a dedicated low-income program? And a great example was LED bulbs. We used to try and reach low-income customers, work with low-income agencies. When they would come into the agencies, customers would get bulbs. It was very expensive for us to administer that program. We actually found that we had a super high uptake from low-income customers in the mass market program, just having the direct free shipped LEDs to them rather than going to the agency. So we were actually able to reach those customers in a far more cost-effective manner and eliminated that low-income agency bulb program because it wasn't any more effective in reaching them and cost considerably more.
Thank you for the answers and the education. I appreciate it. No further questions.
Commissioner Caston.
I'm back. The BYOT, the T-stat, the thermostat question, I know during our discussion conversation questions, it was touched on, then I think I heard the response or understood the response, and then Commissioner Carol Williams, and I want to make sure is the BYOT, are you saying that it is primarily for demand control, to shade peaking, I get that, but it is not an EE device, or it is an EE device?
So that's a very good question. So the smart thermostat, we actually do have an energy efficiency incentive for. It only looks at the energy savings of the smart thermostat, because I think Chairman Williams threw out the term double dipping. We're not trying to double dip on savings. So we have an energy efficiency incentive that just promotes the customer to go out and buy the thermostat. That's one program, and there's an incentive for them to go purchase it, and it will deliver energy savings because of the programmable nature of it, the fact that you can control it remotely. We did not factor in any capacity savings for that in justifying the incentive amount. However, in order to participate in the BYOT program, you have to have an eligible smart thermostat. It is possible that a customer could have gotten an energy efficient incented thermostat and then use that thermostat to participate in BYOT. BYOT's capacity savings are really in lieu of what used to be done through a switch. There used to be a switch on an air conditioner or the heat pump that when the company pressed it, it would just shut it off. It's a little bit more customer friendly and actually a lower cost approach to use thermostat setbacks and control from the utility rather than having to go put a switch on the air conditioner. So it's doing the same thing, but BYOT is just that, you giving the utility control of it. And so that's why there's capacity savings. But yes, a smart thermostat is also considered an energy efficiency measure.
Is that just by Duke, or is that by the manufacturers? Is that by everyone? Or
So-
who makes that determination?
So the eligibility for energy efficiency, I think all smart thermostat manufacturers would try to say that their thermostats are an energy efficiency measure. It would reduce consumption. However, not all smart thermostats are controllable by Duke, so not all of them can be in the winter BYOT program. So they can't all say that they're demand response capable.
So by demand response capable and by being smart, and this is what I'm really trying to understand with the BYOT, is it simply a thermostat that Duke can control also, that simply, and I'm not trying to oversimplify it, but I have to, and I'll let y'all complicate it for me, but that there's nothing magical or mystical beyond it will simply adjust the temperature up or down during a peak time.
Yeah.
And okay, for example, I actually have one that looks pretty cool, and I don't know how to use it for anything because it's got too much stuff. But tied to the functioning of the HVA system in the air handler, where there's like 60 different fan speeds and settings, that I don't have my temperature go up, down, or anything. It stays there, and the demand or the energy usage is simply reduced by the fan and the fan speed and the circulation. To me, that's kind of energy efficient.
That is.
But when I leave and decide to turn my thermostat up, I come home, it's hot. But it helped you with your peaks. And I get that. That's smart. Not sure I personally would consider that energy efficient, but that's neither here nor there.
I think you're spot on. We are not arguing that winter BYOT is an energy efficiency program.
Okay.
It was filed for and approved as a demand response program. It does not recognize any energy savings, so there are no net lost revenues associated with it. It is simply I'm trying to make it as simply as possible. It's just like a switch. It's just going to shift the usage.
Got it. It's just primarily for a peak shaver, and that's it. And finally, as I listen to all this, and those who have heard before probably get tired of me making these analogies, especially related to water and wastewater, but it's what I know. And a good many years back, when water saving devices became ubiquitous and all new fixtures, low flush toilets and such as that over the course of time, especially if you looked at what our per capita usage was, and over the course of time, by the influx and the ubiquitous nature of these devices coming into play, even for old houses, because your old fixture wears out, you eventually have to replace them.
Right.
The per capita demand literally went down significantly to where even when we were looking at water supply and even future water supplies, it kind of flattened that curve too, based on those kind of things. Now, I'm not saying that is the same as energy efficiency relative to electrical utilities, but to me, the concept is the same or should be the same, in my opinion, I believe. So with water saving devices, low flush toilets and such as that, you see a result over the course of time. With this Smart Saver Solar program, is that right? Say it fast 3 times. Again, I don't need to belabor the point. I see the generation. You're taking generation that would be used in the grid, and it's being produced by the end user. I get that. I'm not sure I'm seeing the parallel or the similarity to low flush toilets.
So I think it would be something like a rain barrel.
Mm-hmm.
If customers adopt rain barrels, you're going to see it's water conservation. This is energy conservation in my mind. Does that help? I think that's a very apropos analogy.
Good analogy. Let's just continue the discussion, continue the hearing, and let's just see where we all get to at the end of the day.
Yep.
Very good, though. Thank you very much.
All right. Before we take our lunch, I had one quick question for you, sir, just so I can make sure I understand your perspective. Now, we've talked about energy efficiency light bulbs. Use light up a room, but they use less electricity. And I think you compared those bulbs to solar panels in terms of
They reduce consumption.
they reduce consumption. Okay. And I can't remember who brought this up, but and maybe it's a phantom memory, but I seem to remember someone raising the issue of, I describe it as overuse. Say because I have solar panels, I use more. But couldn't the same be argued for LED bulbs because they use less energy? I keep the lights on more than I would turn them off if I had.
Yes, Chairman, it's a great point, and it's something that measurement verification determines. So we'll actually be able to measure and see what the reduction in grid consumption from the reduction in the customers behind the meter consumption is, and see that. So if it's not reducing the consumption, that will come out in measurement verification. Just like to your point, it's very common where a customer will put in a new air conditioner and they may now think, hey, I can keep the same bill, but turn my air conditioner cooler in the summer. And so there is that, but it's done through measurement and verification to determine what the actual reduction in customer consumption is. So that's how we determine what is the appropriate reduction. It's actually what we're measuring and verifying being reduced behind the meter.
All right. We're in recess until 2:45.